Good morning, we're on the record. Good morning. As chairperson of the Alcoholic Beverage and Cannabis Board for the District of Columbia, and in accordance with DC Code Section 2-571 et seek of the Open Meetings Act, OMA, I'm welcoming you to the regular scheduled meeting of the Alcoholic Beverage and Cannabis Board. This meeting is being conducted pursuant to guidance made available by the District of Columbia's Office of Open Government regarding electronic meetings held by public bodies. Electronic meetings by the ABC Board are authorized pursuant to Section 2-577A of the DC Code. Pursuant to the OMA requirements, notice of today's meeting was provided 48 hours in advance of the meeting on ABCA's website and on the District Central meeting calendar. The notice includes the time, date, agenda, and call-in or login information for public participation. This electronic meeting has been hosted by a WebEx account provided by the District of Columbia government. Please address any questions or complaints to the OOG at opengovoffice@dc.gov. My name is Donovan Anderson. I'm chairperson of the board. I would like to introduce the other members of the ABC board who are also participating electronically. Please respond when I announce your names. Mr. Silas Grant.
Mr. Silas Grant, present.
Ms. Terry Janine Quinn.
Ms. Terry Janine Quinn, present.
Mr. David Meadows.
Good morning, Mr. David Meadows, present.
Mr. Ryan Jones.
Mr. Ryan Jones, present.
Mr. James Turner.
Good morning, James Turner, present.
The board has 6 members in attendance for the conduct of business today, and that constitutes a quorum. Before we get underway with today's hearing calendar, I need to make a few instructions very clear so that the conduct of these hearings is understood by everyone. There are 8 cases scheduled for this morning's calendar. Once your case is called, I will take a moment for IT specialists to elevate the rights for each party to enable their camera and microphone. Then and only then will you have the ability to enable your equipment. If your case has not been heard, you will remain mute and your camera will be disabled. At the conclusion of each case, the parties will have the option to leave. If the party chooses to stay, all cameras and microphones for the concluded case will be disabled. Should you have any questions or require technical assistance during the hearing, please submit them using the question and answer feature. Our first case this morning is a protest hearing status, case number 26, PRO 00048, 70 DC Bev Co., license number 135513. Good morning, Mr. Oriana. Can you please elevate the rights of the parties in this case?
Good morning. Sure. Cameron Mixon, access elevated. And I'm going to check in the chat, but that appears to be all.
All right, thanks. So let's see. I think we're looking for Mimsy Linder or Topar Matthews from ANC2E.
Call in user to unmute. Okay, sorry.
This is
Is there
Commissioner
anyone here
Lindner.
from ANC? Are you here from ANC2E?
Yes, I am. This is Commissioner Lindner, Mimsy Lindner.
Okay, all right, good morning. All right, I'm sorry. Good morning, Mr. Mixon. Can you identify yourself for the record?
Good morning, Mr. Chair. Cameron Mixon, counsel for the applicant, CAMERON, MIXON.
Good morning, ma'am. Can you please spell and state your name for the record and who do you represent, ma'am?
This is Commissioner Lindner, Mimsy Lindner, MIMSY, last name LINDNER, and I'm with ANC 2E.
Good morning, ma'am. All right, Mr. Mixon, are there any preliminary matters you need to bring to the attention of the board?
None for the applicant.
Ms. Lindner, are any preliminary matters you need to bring to the attention of the board?
No, we are working with the applicant to get this matter settled. It's just taking a little time, but we're close, very close.
All right, so if this matter is not settled, excuse me, scheduled for a protest hearing on September 23rd at 1:30 p.m. I guess let me ask the parties, do you believe that this matter will be settled by the protest hearing or the protest hearing or excuse me, or is this a case that you believe that will definitely be settled? Because you're aware that in order for us to move to a protest hearing, the board will need to assign an investigator to this case. So is that necessary, or is it that the parties strongly believe that this matter will be settled?
We anticipate this settling prior to the protest hearing.
Yes,
Then I
this
would
is Commissioner Lindner. Yes,
Yes,
we
ma'am.
agree. We will be for sure settled, God knows, hopefully by even next week.
Well, of course, the board supports settlement, so I would like you to advise the agency as soon as possible, as long as there's a settlement agreement in place, and if it needs to wait for the ANC to vote, then we can continue the hearing. But as scheduled, this matter then is scheduled for protest hearing on September 23rd at 1:30 p.m. Just want to advise the parties, if this matter goes to a protest hearing, then the parties are required to file a PIP 7 days before the hearing. But from what I'm told, it appears it's going to be settled. Good luck with your negotiations, and please advise the agency as soon as possible if you believe that this case will be settled, so therefore the agency will not assign an investigator to this case, okay?
Thank you very much.
All right, thank you. Have a great day.
Bye-bye.
All right, thanks. All right, the next case on our calendar is case number 26 CMP 00038 MK Lounge U Street, license number 131092. This hearing is canceled due to the filing of an offering compromise for the board's review and consideration. The next case on our calendar is case number 26 CMP 00035 Cloud One Restaurant and Lounge, license number 111411. Mr. Oriana, can you please elevate the government in this case, please?
Sure thing. Alicia Hogan Miller, access elevated. That is all, Chair.
All right, thank you. Good morning, Ms. Hogan Miller. Can you please spell and state your name for the record?
Good morning, Assistant Attorney General Alicia Hogemiller, ALYCIA, HOGENMILLER, on behalf of the government.
Good morning, ma'am. Mr. Mixon.
Cameron Mixon, counsel for respondent, CAMERON, MIXON.
Good morning, Mr. Mixon. Ms. Hogan Miller, are there any preliminary matters in this case?
None from the government.
Mr. Mixon?
And none for the respondent.
All right, fine. If this matter is not settled, it is scheduled for a show cause hearing on October 7th at 10:30 a.m. Just want to remind the parties that 7 days before the hearing, the parties are required to file documents and witnesses they wish to rely upon at the hearing. Failure by either side to timely disclose documents and or witnesses, the board is empowered to prevent that side from moving forward. Any questions?
None from the government.
All right, thank you. Have a great day. All right. The next case in our calendar is case number 26 CMP 00022. Sushera, Susheria, license number 72014. Mr. Morena, can you please elevate the licensee for this case?
I don't see the licensee, but I'll check in the chat.
All right, fine, thanks.
Alfredo Fraga, access elevated. That is all, Chairman.
Thank you. Mr. Fraga, are you able to come in camera, sir? Hello, are you able to come in camera? All right.
There you go.
All right, thanks. Good morning, Ms. Hogan-Miller. Can you please identify yourself for the record?
Assistant Attorney General Alicia Hogan-Miller, ALYCIA, HOGENMILLER, on behalf of the government.
Good morning, ma'am. Mr. Fraga, can you please spell and state your name for the record and your relationship to this establishment?
Alfredo Fraga, ALFREDO, I'm one of the owners of the property.
Good morning, sir.
Good morning.
Ms. Hogan-Miller, are there any preliminary matters in this case?
Nothing from the government.
Any preliminary matters you need to bring to the attention of the board, Mr. Fraga?
No, we are in a reorganization. We filed for Chapter 11. Now our accountants has taken over all our books, so everything has been passed to the accountants. It was a report was filed with the wrong day. It was filed late with the wrong year. It was honest mistake. But I believe everything has been taken care.
Mr. Fraga, this is just the show cause hearing status. You can discuss. Whose case is this, Ms. Hogan-Miller?
This is my case.
Okay. Well, you can offline. You can discuss this case with the government. If you are unable to settle this matter with the government, then this matter is scheduled for a show cause hearing on October 7th at 10:30 a.m. If this matter is not settled, sir, then you can provide an explanation to the board on October 7th at 10:30 why the report wasn't filed timely. If this matter goes to hearing, you are required to file a document. You need to file your disclosure, meaning that 7 days before the hearing, you have to file the documents and witnesses you'll be relying upon at the hearing. So you would provide a copy of the document to Ms. Hogan-Miller, and you'll also provide a copy of the document and or witnesses to ABCA Legal. And this document must be filed 7 days before October 7th. Failure by either side to timely file these documents, the board is empowered to prevent you from relying on documents and or witnesses that were not timely disclosed. Do you have any questions, sir, before I end this hearing?
No, I don't have any questions.
All right, so you guys can settle this matter if you can. If not, I will see you on October 7th at 10:30 a.m. All right? Thank you.
Thank you very much.
All right. All right, the next case in our calendar is case number 25 CMP 00102, Mark's Cafe American Bar, license number 122472. Mr. Oriana, can you please elevate the rights of the licensee in this case?
No licensee, Chair.
All right, thank you. Ms. Hogan-Miller, can you please identify yourself for the record?
Assistant Attorney General Alicia Hogan-Miller, ALYCIA, HOGENMILLER, on behalf of the government.
Good morning, ma'am. I see the licensee is not here this morning, but at show cause hearing status, there is no requirement for the licensee to appear. If this matter then is not settled, It is scheduled for a show cause hearing on October 7th at 1:30 p.m. Just want to remind the parties that 7 days before the hearing, the parties are required to file documents and witnesses that they will rely upon at the hearing. Failure by either side to timely disclose documents and/or witnesses, the board is empowered to prevent that side from relying on documents and witnesses that have not been timely disclosed. All right? Thank you for your appearance in this case, ma'am. All right. The next case on our calendar, it is case number 26 CMP 00040 Hotel 5, license number 90189. This case has been canceled. An offer and compromise has been provided to the board for its review and consideration. The next case on our calendar is a show cause hearing. This is case number 25 CMP 00109 Tipsy Lounge and Restaurant 1, license number 111411. Mr. Oriana, can you please elevate the parties in this case?
Sure thing. Investigator Kendall Williams, access elevated. Colin Chenchi, access elevated. And that appears to be all, Chairman.
Mr. Chenchi, were you expecting the licensee to appear today, sir?
I have not heard from the licensee in any regard about this matter.
All right, thank you. All right. Are you prepared to, is the government prepared to move forward ex parte, sir?
We are prepared to proceed ex parte. The district will intend to move for a default.
All right, let me have you identify yourself for the record, sir. Please identify yourself for the record.
Yes, Mr. Chair, Colin Chenchi, COLLINCENCI, Assistant Attorney General with the Office of the Attorney General for the District of Columbia.
Good morning, sir. I see that the licensee is not here this morning. And as I'd stated before, I'd ask you if the government prepared to move forward ex parte. You said yes. So pursuant to DC Official Code Section 25-447E, the board has the authority to proceed ex parte where the licensee waives the hearing or fails to appear unless a hearing is extended for good and sufficient cause. The board's record reflects that the licensee was properly served. Seeing a licensee here today and having no good and sufficient cause to extend the hearing, the board will proceed with the show cause hearing. How did you plan to proceed, Mr. Chenchi?
Yes, Mr. Chair, at this time, the district moves to find the establishment in default and have the board find in favor of the district.
And what is it that, in order for the board to make that determination, so you have to at least provide us some information in the record. So what is it that you plan what's the basis for you asking the board to find the licensee in default?
Yes, Mr. Chair. First, the licensee has failed to attend both the status hearing and the show cause hearing in this matter. While the licensee is obviously not obligated to attend the status hearing, their failure to attend both hearings indicates a lack of engagement with the case, and their failure to attend today is tantamount to concession of the facts in the show cause notice. As the board is aware, the show cause notice is deemed admitted by DC regulation automatically into the board's record. So the board has facts on the record in order to make a determination about the charges assessed in this case. There will not be evidence presented to the contrary, of the case report, given that the licensee is not present to present that evidence. Given that the licensee has not attended, and given the simplicity of two charges in this case, failing to ensure that the establishment security cameras were operational and failing to provide requested video footage within 48 hours of an ABCA investigator's request, the case report stands on its own and speaks for itself and provides the board with sufficient information in order to make a ruling on the merits of this case. Based on the licensee's clear contempt for the board's procedure by not attending any of the hearings that were set in this case, the district would ask that the board impose the highest possible penalty afforded to it under DC code.
So I know that the case report is in the record, but just for this hearing, just why don't you, for charge one, the failure to ensure cameras were operational, why don't you just put on the record in this case, what is it that the case report states on that charge, please?
Yes.
Hold on. I don't think we need Mr. Williams. So thank you for being here today, sir. You don't need Mr. Williams, Mr. Chenty. Is that correct?
If the board does not intend to hear testimony, then no, we do not need Mr. Williams.
I don't think testimony is well, you know what? I will let me not dismiss him. That's your call, but I need sufficient evidence. At least I need you to put information on this record and not just what's in the case report, that will at least the board will have what if Mr. Williams was going to testify, what it is that he would testify to. You could do that from the case report, please.
Yes, Mr. Chair. The case report does summarize the substance of what Mr. Williams' testimony will be. Indicates that on Sunday, October 26, 2025, at approximately 12:20 a.m., Investigator Williams visited Tipsy Lounge and Restaurant 1 to notify them about an after-hours operation complaint. After they responded to the establishment, they spoke with ABC manager Helen Hailu. At that time, Investigator Williams asked Ms. Hailu for security camera footage for the previous night, October 25th, 2025, from the hours of 2:30 a.m. to 4:30 a.m. Investigator Williams did not receive that video camera footage in the time that he had requested it. On Wednesday, October 29th, 2025, so that would be 3 days later, Investigator Williams sent a follow-up email to all of the contacts that ABCA had available for this establishment. That included Rizman Shah, Daniel H. Kaufman, Diamond Hiralal, and Daniel Azbeha. Mr. Williams sent an email.
Mr. Chenty, can you please spell those names to help the court reporter, please?
Yes, these names are contained in the case report. Rizman Shah, Rizmanshah, Daniel H. Kaufman, Daniel, Koffman, Diamond Hiralal, Diamond, Heerallal, and Daniel Azbeha, Daniel, Azbeha, Asbeha.
Thank you.
Investigator Williams sent an email to these individuals, again requesting the security camera footage, and only after he had sent that follow-up email was he able to receive some of the security camera footage that he had requested.
All right, so that's the case. That's the evidence on charge one. And what's charge two?
Yes, the case report goes on to summarize that Investigator Williams accessed the footage that was sent over to him on November 1st, 2025. Upon reviewing that footage, Investigator Williams realized that the footage provided was only for the outside security cameras, not the establishment's internal security cameras, which Mr. Williams himself observed when he was present in the establishment on October 26. He then followed up with the establishment and requested that the security cameras for the inside of the establishment also have their footage provided. He did not receive that, again, within 48 hours of his request. It was not until November 9th, 2025, where Investigator Williams made contact with Mr. Azbeja. Mr. Azbeja told Investigator Williams that the external camera security footage was the only footage provided because the other cameras, the internal cameras, were not working during the times that Mr. Williams had requested. And under the ABCA code, for security cameras operating in licensed establishments, while the establishment is operating, all cameras that are within the establishment need to be operational, capable of recording, and actually recording.
Thank you, sir. Before, I guess, any questions that we could throw Mr. Williams in, any questions any board member believe that they would have for Mr. Williams, although on the case report? All right. Since the board members has no questions, so just once again, Mr. Chenchi, just wrap up what it is that you're asking the board to do, please.
Yes, based on the licensee's failure to attend and based on the summary of the violations within the case report, which is not contested by any evidence, the district asks that the board find in its favor on both charges, and based on the establishment's contempt for these proceedings by failing to attend both the status and the show cause hearing, the district asks that the board impose the highest possible fine permitted under DC code.
Thank you, sir. All right. As chairperson of the Alcoholic Beverage and Cannabis Board, in accordance with DC Official Code Section 2-575 of the Open Meetings Act, I move that ABC Board hold a closed meeting for the purpose of seeking legal advice from our counsel on case number 25 CMP 00109, Tipsy Lounge and Restaurant 1, pursuant to DC Official Code Section 2-575B4A of the Open Meetings Act, and deliberating upon case number 25 CMP 00109, Tipsy Lounge and Restaurant, for the reasons cited in DC Official Code Section 2-575B13. Is there a second?
Mr. Grant, I second the motion.
Mr. Grant has seconded the motion. We'll have a roll call vote. Mr. Grant.
Mr. Grant, I agree.
Ms. Quinn.
Ms. Quinn, I agree.
Mr. Meadows.
Mr. Meadows, I agree.
Mr. Jones.
Mr. Jones, I agree.
Mr. Turner.
Turner, agree.
And Mr. Anderson, I agree. As the motion has passed 6-0, I hereby give notice that the board will recess this to hold a closed meeting pursuant to Section 2-575 of the Open Meetings Act. The board will issue a decision within 90 days. Thank you very much, Mr. I know you didn't testify. Mr. Williams, thank you for being here today. And Mr. Tenchi, thank you for being here as usual. You have a great day.
Thank you. You as well.
Thank you. All right. Thanks. Bye-bye. All right. All right, the next case in our calendar is a fact-finding hearing on Letena, L-E-T-E-N-A, license number 104754. Mr. Oriana, can you please elevate the rights of the parties? in this case?
Sure thing. Yamrod Ezina, access elevated. That is all, Chair.
Thank you. Can you please come on camera, ma'am, if you're able to? Ms. Ezina, are you able to come on camera, ma'am?
Sending the individual
Thank you.
request to mute. There she is.
Okay, she's fine. All right. Good morning, ma'am. Can you please spell and state your name for the record?
Yamrotizina, Yamrotizina.
And what is your relationship to this establishment, ma'am?
The honor.
All right, good morning, ma'am. Now this is a fact finding here, ma'am. It's my understanding that you are operating you have a Class C restaurant license with an approval of distillery pub endorsement. And you're trying, if I understand, you're trying to change your class of license. So why don't you explain to the board? This is basically the agency is trying to find out what it is that you're trying to do, and whether or not this is something. What are the pros and cons? So maybe you can explain to the board currently what type of license do you have? What do you currently do? And what is it that you're trying to, what change are you trying to make, ma'am?
Okay, we've been operating as a restaurant for the last 9+ years, and recently we basically installed a mini distillery that is currently producing, and we're from restaurant we changed to a distillery pub. That came with licensing fee that is equivalent to a manufacturing, but unfortunately we haven't been given the full right of a manufacturer, which is the ability to distribute within DC. So that is basically limiting us in terms of the market we can access, and we basically were hoping at least we'll have the access of other Ethiopian restaurants to sell our liquor. So our hope now is to get that privilege as well with the actual fee.
But you are a restaurant, and so therefore, based on the endorsement that you have, you are able to sell your own product, but you cannot sell it to your customers, but you cannot sell it to the general public.
We can't. Sorry. Okay.
I'm sorry. Go ahead, ma'am.
We can sell it at the restaurant, but not outside of the restaurant as such.
Right.
Yeah.
Now, so your intent is that you want to sell what? So what is it that you're producing?
It's
Your
an Ethiopian
manufacturing, I'm sorry.
specialty. It's an Ethiopian specialty spirit.
All right. And so your intent is that you want to sell that to the general public. So you want to make it available to anyone who buys it, other restaurants, other bars. Is that what you want to do? Is that
That's
correct?
correct. Yes, that's correct.
So in order for you to do that, you know that you'd have to in order for you'd have to give up your restaurant license.
That was what I was told. I mean, I will be able to change the C to manufacturing license.
No,
but that would still, I mean, the explanation may not be right, but we've been going through quite a few back and forth, but no, this being quite new to ABCA, they haven't been able to give me the exact procedure or the exact change that I need to make.
All right. So you couldn't now. You couldn't operate as a restaurant, so you'd have to give up your restaurant license. So you couldn't operate as a restaurant anymore. And
so, okay. So that would mean that I won't even be able to sell food. Is that what it means? Because my understanding was that, yeah. I would be able to sell food anyways, so, and the drinks. So I thought it would just be similar to what I could be able to do.
No, because if you have a manufacturer license, you could only sell your spirits. So you couldn't sell any other spirits. So yeah, you could have a restaurant, but you could not sell any other spirits with the exception of what it is that you produce.
That makes sense. Yes, that's how it was explained to me. Yeah, I will be able to sell the food and whatever we produce on site in terms of spirit. And we will need to give up the wine and beer, if that's what I was, if that's
Because
correct.
I'm saying the only spirit that you could serve on the premises is the spirit that you produce.
That's fine. Yes, I understand that.
And so I guess, do you understand that by changing your license to a manufacturer Class A, your CR privileges are permanently relinquished? So you can no longer operate as a restaurant?
In terms of spirits and drinks,
In
as
the
in
sense that
alcoholic drinks. Is that what it means?
Are currently, as a restaurant, what do you serve as far as beer, wine, and spirits?
We sell all beer, wine, and spirits. But
You sell all type of beer, all type of wines,
yeah,
and all type of
yeah,
spirits.
yeah.
And so you are aware that you could no longer do that.
Yes, I'm not given any other options. So yeah.
Well, ma'am,
Yeah.
you're the one who you're the
Yeah, it's
one.
just, I mean, we're giving up a significant amount of sales from beer and wine, no question about it. But in the meantime, foot traffic is very low, so we want to be able to access market outside of our four walls. So it's just better of two difficult decisions to make.
In that you will have to reapply for a completely new retail license from scratch, subject to public notice, ANC protests, and potential moratorium.
That's if I want to go back to the C, is that what you mean? Or
What I'm trying to find out is if you're as a manufacturer, I'm trying to see if you apply for a manufacturer license. Let me see. Right, because you're applying for, so you are applying for a completely new license. So you're applying now for a manufacturer license, which is subject to public notice, the protest period. And where is this that you're located?
in Columbia Heights, 14th Street.
Where is this? Is this close to the U? I'm trying to figure out if you're
It
close to
is.
the U Street where the moratorium is.
No, it's way further up. We are on Park and 14th Street. Park
Okay,
Road.
so you're all the way up. I'm not aware if I don't believe that there's any more. I am off the top of my head. I'm not certain if there's any moratorium in that. There's no. I'm not aware of whether or not there's any moratorium in that area. And now another comment. If the class change is approved, are you aware that you will no longer be able to sell and serve wine and beer to patrons?
That's correct. Yeah.
Are you also aware that the spirits that will be offered for sale at the establishment would be limited to spirit distilled at your licensed location?
Yes.
Are you currently utilizing your distillery pub to manufacture spirits at this location?
Yes.
So what spirits are you currently manufacturing at this location?
It's a specialty Tariq Arage. It's an Ethiopian specialty drink.
Can you spell that for the record? We have a court reporter, please. Just spell that for what the drink is, please.
Okay. Tariq, Tarik, Arake, Areke.
And what, and again, what is that, ma'am?
Um, the category is not is in under specialty, but it's an Ethiopian specifically specialty drink.
Okay, that's fine. So what is your plan for the physical footprint of your current dining room and kitchen?
We currently we have about 2,500 square feet area, so we're going to remain as we are. We're not going to change the actual layout.
But how do you intend to make room for your manufacturing equipment? Because you'll
Oh,
be
it's already there,
manufacturing.
and we
Go
had
ahead.
a backspace. We had a backspace which didn't even interfere with the dining area. So we're gonna remain as we are. So the actual equipment is in the back.
But so you're saying that you plan to, you still want to sell food at your current location, is that correct?
That's correct, yes.
But how do you expect to match revenue compared to your restaurant sales, especially if you do not if especially if you do not have a diverse collection of alcoholic beverages?
I mean, our alcoholic sales was about 3% anyways. So it was never higher than that. But with the new revenue that we hope will come from Tarikarege, we'll be able to compensate for that, compensate and more.
I mean, this is your vision, this is what it is that you want, but are you saying that the specialty Ethiopian spirits that you wish to produce, you're saying you believe that it is that popular that your revenue would be significantly increased?
Yes.
So, so are you planning to sell spirits directly to other licensed alcohol retailers?
Yeah, that's the plan, because we already have restaurants and ABCs, I mean, alcohol liquor stores that are interested in buying, and then we've realized there's a huge demand for it. So
All right, let's see how. I'm trying to see if any other questions. Any questions? I know this is something new for the agency and for the board. So while I'm looking to see if I have any questions that any board members wish to ask, you're welcome to go ahead and ask.
Mr. Chair,
Yes, Mr. Turner.
at your location, I'm quite familiar with it. It's in part of DC, USA, I believe, on the northern end. And it's a rather large restaurant space for the area.
right.
Is the manufacturing or the just manufacturing and producing of I forget the name, I think it's called Ethiopian tequila.
Yes, yeah, you can call it that, yeah.
It's in a separate part, not directly connected to the restaurant, or is it directly connected?
It's actually directly connected. The restaurant space is about 2,500, and 500 of it in the back is what we're using for manufacturing. Yes.
I believe some of the issues here are related to having the spaces combined of manufacturing, distributing, and having a restaurant. So that's causing you to have to choose one or the other in these, instead of perhaps maybe creating or separating the businesses and having a manufacturing and having a restaurant. So
Right.
there are things here that might be alternatives for you to think of, because I believe the board wants to help businesses survive and thrive. That's some of the difficulty we're having here of this combined effort. And if you can give us a better understanding of, do you really just want to be a manufacturer of this spirit and that be the only thing you can sell of a alcohol nature in your restaurant?
I mean, I'll tell you why we wanted to go for this alternative. Like I said, the proportion of our revenue doesn't come from spirit sales mainly. It is from beer, wine, and recently from Tarikarege. And over the last year, I mean, business has been really slow, and the foot traffic to our restaurant hasn't been that great. So this alternative for us is it gives us an option to actually access other restaurants within the district that has higher traffic and who has more interest in the liquor or in the spirit. If we just adhere to what we're doing now and keep selling other spirits and wine, I don't believe we can stay in business. That's the problem now. So we're trying to see if this could improve our monthly income, really.
Any other questions, Mr. Turner? Do you have any other questions, Mr. Turner?
No, sir. Thank you.
Any other questions by any of the board members? Go ahead, Mr. Meadows.
Yes, hi, good morning. So your Turk okay, you have that copyrighted? Do you have a name, like a Smirnoff or a Bacardi? Do you have a name that you're titling it?
Unfortunately, it's a new category. So that's one thing I'm working with TTB to bring it as a new category. But otherwise, it just falls under specialty drinks.
And so right now, you don't have a copyright.
I have trademark.
You have a trademark, and that's
Yes.
for Latina restaurant or for the spirit?
For Tari Karage.
Okay.
Yeah.
And you're also requesting a change of hours. Could you explain what that request is?
No, hold on. There's no change of hours. I mean, what they're asking for right now is they want to change their license class, and so I think
That's what I'm reading right here. It says request for class change of hours, and on-site sales. But that's what I'm reading.
Go ahead. I'm sorry.
I
go ahead.
mean, the only reason I requested for change of hours is not because I wanted to, but I was told that that is a requirement. For us to get a manufacturing license, we had to change the hours. That was the only reason. Otherwise, I don't mind keeping the current hours.
Okay.
So what are the current hours? I apologize, Mr. Matthews. So what are Mr. Meadows? I apologize. Yeah. So what are your hours and what are you asking for? Yeah.
The current hours are from morning 10 a.m. to on Monday to Friday, I think is about 12, and then Friday, and Saturday are until 2 a.m. And I was told that there's a limitation in terms of hours that we can operate as a manufacturer. So I shortened those hours.
Which are shorter hours, Mr. Meadows.
Yes.
So it's shorter hours. It's not longer hours. Okay. I apologize. Go ahead, Mr. Meadows.
That's it. Thank you very much. All the best.
Any other questions by any other board members? Anything else? Anything else you want to say, ma'am?
I mean, all I want to say is the ideal position was to actually operate as we are now, because every revenue that we get helps. But if that was not a possibility, is definitely this option is what we like to go for.
The purpose is to make it clear to you that you're asking for a manufacturer's license, so you're going to go through the protest period. So you have to apply for a new license. You have
So
to
would that mean? So
Go
would
ahead.
that mean like while I'm waiting for the manufacturing license, I would be without license, or will I be able to use the current license for it?
mean, I think we can discuss this internally with the agency. I guess my assumption is that you can continue operating as a restaurant until that license is granted, because of course you have to go through the protest period. It has to be there's a 45-day protest period to see if it's gonna. You have to submit an application. then it has to be placarded. We have to wait for the protest period. So I don't see any reason why the agency would not allow you to operate as a restaurant. However, hold on a minute, hold on. Oh, I apologize. They don't need a protest period. I need to get more info. All right, let me see. All right, they're probably not a protest period, but I this is something can be discussed with the agency in the sense that until that license is approved, then you can continue operating as a restaurant. However, you cannot sell the product because you cannot sell the product until you get the new license. You cannot sell the product to any other establishment. You can only sell it to your customers. So yeah, so you can continue operating under your current license, under a current restaurant license to do what you're currently doing until it's approved.
Right.
So I want to declare though that you cannot sell it to non-restaurant customers.
Mhm.
All right, so until the license is issued, you cannot sell it to a liquor store. You cannot sell it to anyone unless it's the current license, your current restaurant license. You can continue operating as a restaurant. You can continue operating, selling beer and wine as you have. But as soon as we issue the license, then you would have to stop.
Sure. Okay. Sounds good. Thank you.
But I want you, though, ma'am, to be clear that if this license is issued, you can no longer sell beer, wine, or any other spirits without you can no longer sell beer or wine or any other spirits except for the one that you manufacture in-house. Is that clear to you, ma'am?
Yes.
So, but let me ask you a question. What's the alcohol by volume in the spirit that you want to mass produce?
40%.
40%. And so
Yeah.
how much how much spirits do you believe that you would be able to manufacture? I don't know. Tell me about what's your business plan in the sense of how much do you plan to manufacture?
Current capacity is about 10,000 a year.
Is that a whole lot? I don't know. I'm asking. What does
It
that?
is. I mean, in terms of business, yes, it is.
All right. Let me see. Okay. All right. And so the new hours is that as a manufacturer, you'd have to stop. You'd have to stop at the hours of operation for manufacturers that you'd have to close at midnight. That's the latest that you
Yeah.
can you'd be open.
Right.
All right.
Yeah.
Do you have any other questions, ma'am, that you want to ask us?
No.
Well, all right, we will think about it some more. We'll provide some guidance to the agency,
Okay.
and you will be contacted by the agency next steps. But I just want to inform you that you can continue operating as a restaurant through this process. I just want, however, to remind you that you cannot sell the product to anyone who's not a customer of the restaurant until the new license is issued to you.
Okay. Thank you.
All right. Anyways, as I stated, we'll take this matter under advisement and we'll issue some guidance shortly on next steps. Thank you, ma'am. Have a great day.
Thank you. You too.
All right.
Bye-bye.
All right. We're at the end of our calendar for the morning. Let us now do our agendas. Let me do the legal agenda. Alcohol on the legal agenda, alcohol, there are 7 items on the agenda. I'm going to review all 7 items on the agenda. Then I will provide some recommendations. Then I'll ask the board to approve the recommendation that's put in the record by the chair. So number 1 on the legal agenda, alcohol, number 1, review of a settlement agreement. This is in Cuba Libre Restaurant, license number 082457, recommendation approval. Number 2, review of a settlement agreement. This is for Wild East Club, license number 136372, recommendation approval. Number 3, it's an offer and compromise in case number 26 CMP 00039, Hotel Hive, license number 090189. And the offer in compromise for Hotel Hive is fail to file required quarterly statement, statutory authority DC Code Section 25-113B2A. There is a $1,000 fine paid within 30 days, or the license shall be suspended indefinitely until the fine has been paid. Further, the license shall be suspended for 1 day, which is stayed for 1 year if there are no subsequent quarterly statement violation. And other term, submit pending quarterly statements if they have not been submitted. And the recommendation is approval. Number 4, review of motion for reconsideration. This is for Consortium for Sustainable Work, for the consortium. License number, this is in case number 26PRO00043. The consortium license number 130329. Recommendation deny. Number 5, recipe for dismissal. This is in case number 25 CIT 00623. Hot and Juicy Crawfish, license number 086226, recommendation approval. Number 6, review of request to extend protest period by a group of 5 or more. This is in case number 25 CIT 00623. This is it's AC608. It's a trade name. I'm sorry, AC608 LLC, trade name to be determined. The license number is 136162. This is an FYI to return to legal. That's a recommendation. And number 7, review of request to extend the protest period. This is Buho's Restaurant, license number 133735, recommendation approval. I therefore make a motion that ABC board members vote to approve the recommendation that's put forth by the chair for the legal agenda alcohol. Is there a second?
Mr. Grant, I second.
Mr. Grant and Ms. Quinn, I second the motion. We'll have a roll call vote. Mr. Grant.
Mr. Grant, I agree.
Ms. Quinn.
Ms. Quinn, I agree.
Mr. Meadows.
Mr. Meadows, I agree.
Mr. Jones.
Mr. Jones, I agree.
Mr. Turner.
Mr. Turner, agree?
Mr. Anderson, I agree. The matter passed 6-0. Now let's move to a legal agenda, medical cannabis. There's one matter on this agenda, and it's a review of the letter from ANC 5C. This is ABT LLC, license number 128728. This is just an FYI for the board. This submission will be considered as part of the final board order in the protest matter. That is our legal agenda, medical cannabis. All right. Let's now move to our licensing agendas. All right, give me a minute, please. And on our licensing agenda, there are 4 matters on our licensing agenda. I'll review all 4. I'll make recommendations, and then I'll ask that the ABC board members vote to approve the recommendations as put forth by the chair. So number 1, review application for safekeeping of license. This is Bull Korean Bar and Restaurant license number 126455. Recommendation approval through March 31st, 2027. Number 2, review application for safekeeping of license. This is Seta Oasis, license number 129034. Recommendation approval through March 31st, 2027. Number 3, review application for commercial bingo endorsement. This is for Ivy City Tavern, license number 093795. Recommendation fact finding. And number 4, request to convert the previously requested Summer Garden endorsement to a sidewalk cafe endorsement with seating for 40 patrons. This is for Aurora, AURA, license number 129045. Recommendation approval. I therefore make a motion that ABC board members vote to approve the recommendation that's put forth by the chair for the alcohol licensing agenda. Is there a second?
Mr. Meadows, I second.
Mr. Meadows has seconded the motion. We'll have a roll call vote. Mr. Grant.
Mr. Grant, I agree.
Ms. Quinn.
Ms. Quinn, I agree.
Mr. Meadows.
Mr. Meadows, I agree.
Mr. Jones.
Mr. Jones, I agree.
Mr. Turner.
Turner, agree.
And Mr. Anderson, I agree. The matter passes 6-0. Let's now move to the alcohol licensing supplemental agenda. On this agenda, there's one matter, which is review application for a change of hours to operate later. This is for District Taco, license number 099379, recommendation placard. I therefore make a motion that ABC board members vote to approve the recommendation put forth by the chair for this matter. Is there a second?
Mr. Jones, I second the motion.
Mr. Jones has seconded the motion. We'll have a roll call vote. Mr. Grant.
Mr. Grant, I agree.
Ms. Quinn.
Ms. Quinn, I agree.
Mr. Meadows.
Mr. Meadows, I agree.
Mr. Jones.
Mr. Jones, I agree.
Mr. Turner.
Turner, agree.
And Mr. Anderson, I agree. The matter passes 6-0. We now move to the second supplemental alcohol licensing agenda. There is one matter on this agenda, which is review application for game of skill license to operate 5 kiosks offering the District Edge electronic game system by Paysomatic. This is for Aurora, license number 129045, recommendation approval. I therefore make a motion ABC board members vote to approve this request. Is there a second?
Turner, second.
Mr. Turner has seconded the motion. We'll now have a roll call vote. Mr. Grant.
Mr. Grant, I agree.
Ms. Quinn.
Ms. Quinn, I agree.
Mr. Meadows.
Mr. Meadows, I agree.
Mr. Jones.
Mr. Jones, I agree.
Mr. Turner.
Turner, agree.
And Mr. Anderson, I agree. The matter passes 6-0. Let's now move to the board's temporary license and 1-day substantial change docket. On this docket, there are 11 applications. I will review all 11 in record with recommendations, and then I'll ask the ABC board members to vote to approve the recommendations put forth by the chair. So number 1, a request from Vic, AULAKH, for one-day license Class F Jazz Festival. This is August 20th through August 22nd. The license number is 137002, 500 attendees, 20 security guards. A recommendation approval. Number 2, request from WAKEYA Henry for one-day license Class F. Sumatura Rooftop Event, SUMITOMOS. That's how it's spelled, rooftop event. This is September 16th. The license number is 137024, 40 attendees, 1 security guard's recommendation approval. Number 3, a request from Melissa Klein, KLEIN, one-day license Class F, a bat mitzvah. This is September 5th. The license number is 137058, 65 attendees, 1 security guard recommendation approval. Number 4, a request from Teresa Chavez, a one-day license Class G. Quinacera celebration, QUINECEANERA. The date is September 12th. The license number is 136970, 250 attendees, 5 security guards, recommendation approval. Number 5, a request from Nicholas TSUSAKI for a one-day license Class G, LGBTQ plus social. This is August 15th. The license number is 137022. 48 attendees, 2 security guards, recommendation approval. Number 6, a request from Tisson, TSION. The last name is ZEWOLDE for one-day license Class G, graduation August 22nd. The license number is 137036. 210 attendees, 4 security guards, recommendation approval. Number 7, a request from Jesse Higher, HEIER, a one-day license Class G. This is for Jade Fitness. This is September 26th. License number is 137019. 60 attendees, 1 security guard's recommendation approval. Number 8, a request from Lucas Yomana, a one-day license Class G. Arlo Hotel Staff Party, August 23rd. The license number is 137055. 75 attendees, 2 security guards, recommendation approval. This is a request from Lax Wine and Spirits for one-day substantial change, community event, nature of substantial change, use license off premises to our own parking lot. This is September 4th. The license number is 082054, substantial change license 26SC00851, recommendation approval. Number 10, Oya LLC. This is a pub crawl, U Street Halloween bar crawl, October 24th. The license number is 104072. Substantial change license 26 PCE 00023. Conditionally approved for 1,000 participant. And number 11, Carlos. This is a retroactive event. Carlos Daly, one-day license Class G, Taste of Jamaica. The event was August 8th. The license number is 137027. Recommendation retroactive approval. I therefore make a motion that ABC board members vote to approve the recommendations as put forth by the chair for the board's temporary one-day and substantial change docket. Is there a second?
Mr. Grant, I second the motion.
Mr. Grant has seconded the motion. We'll have a roll call vote. Mr. Grant.
Mr. Grant, I agree.
Ms. Quinn.
Ms. Quinn, I agree.
Mr. Meadows.
Mr. Meadows, I agree.
Mr. Jones.
Mr. Jones, I agree.
Mr. Turner.
Mr. Turner, I agree.
Mr. Anderson, I agree. The matter passes 6-0. We now move to the alcohol license administrative docket that was published for August 12, 2026. On this docket, there are 26 applications, and without objection, I make a motion that ABC board members vote to approve all the applications on this agenda. Is there a second?
Ms. Quinn, I second.
Ms. Quinn, I second the motion. We'll have a roll call vote. Mr. Grant.
Mr. Grant, I agree.
Ms. Quinn,
Ms. Quinn, I agree.
Mr. Meadows,
Mr. Meadows, I agree.
Mr. Jones,
Mr. Jones, I agree.
Mr. Turner,
Mr. Turner, I agree.
and Mr. Anderson, I agree. The matter passes 6-0. And the last agenda item for the morning, it's the medical cannabis licensing agenda. On this agenda, there are 3 matters. Number 1, review of packaging and label submissions. This is for the dispensary license number 127934, recommendation approval. Number 2, review of packaging and label submission. This is for the dispensary license number 135972, recommendation approval. And number 3, review of new product with packaging and label submission. This is for Easy Day Edibles, license number 126412, recommendation approval. I therefore make a motion the ABC board members vote to approve the recommendations put forth by the chair for the board's medical cannabis licensing agenda. Is there a second?
Mr. Meadows, I second.
Mr. Meadows, I second the motion. We have a roll call vote. Mr. Grant,
Mr. Grant, I agree.
Ms. Quinn,
Ms. Quinn, I agree.
Mr. Meadows,
Mr. Meadows, I agree.
Mr. Jones,
Mr. Jones, I agree.
Mr. Turner,
Turner, agree.
and Mr. Anderson, I agree. The matter passes 6-0. We're now at the end of our agenda items for the morning. And so the board will therefore go in recess until our afternoon hearing at 1:30. I now ask all board members to return to executive session for further action. I will see you, the general public, at 1:30. Good morning. Thank you. Good afternoon. We're on the record. Good afternoon, everyone, and welcome to the afternoon session of the ABC board. I think I'm waiting for. Good afternoon, everyone, and welcome to the afternoon session of the ABC board. My name is Donovan Anderson, chairperson of the board. Joining me this afternoon are 5 other board members: Mr. Silas Grant, Ms. Terry Janine Quinn, Mr. David Meadows, Mr. Ryan Jones, and Mr. James Turner. The board has 6 members in attendance for the conduct of business this afternoon, and we do have a quorum to conduct business. Before we get underway with this afternoon's calendar, I need to make a few instructions very clear so that the conduct of these hearings is understood by everyone. There are 3 cases scheduled for this afternoon. Once your case is called, I will take a moment for IT specialists to elevate the right for each party to enable their camera and microphone. Then only then will you have the ability to enable your equipment. If your case has not been heard, you'll remain mute and your camera will be disabled. At the conclusion of each case, the parties will have the option to leave. If the party chooses to stay, all cameras and microphones for the concluded case will be disabled. Should you have any questions or require technical assistance during the hearing, please submit them using the question and answer feature. Our first case this afternoon, it is a fact-finding hearing. It is District Reserve LLC, license number 136719. Good afternoon, Ms. Oriana. Can you please elevate the rights of the parties in this case?
Good afternoon. Yutong Zhu, access elevated. Monette Ballard, access elevated. Jacoby, access elevated. And that appears to be all term.
All right, fine. Can everyone please come on camera? All right. Okay, Mr. Zhu, can you please spell and state your name for the record?
Yeah, good afternoon, Chair and members of the board. As YUTONGZHOU, Yutong Zhou on behalf of District Reserve LLC.
And your client here this afternoon, who's your client?
It's Monet Ballard. Also, Mr. Chair, our witness here, the landlord that's involved party is also on the line. He's under the name Jake, if we can let him in as well.
What's the name? Okay, all right.
Yeah, he's here.
All right, so could Miss Ballard, can you please spell and state your name for the record and your relationship to the establishment?
Monet Ballard, MONET, last name B as in boy, ALLARD as in dog, and owner.
So you're the owner of District Reserve.
Yeah.
I see that you're in a.
Owner.
I see that you're in a. Who's the other owner of the establishment, ma'am?
Nazir, he's here as well.
Good afternoon.
Can he state his name for the record?
Yes. First name MD, middle name Abu, and last name Nasser, NASER.
All right, and I hope that I see you're in a vehicle, so I hope that you're pulled over to participate in this hearing.
Right.
All right. Mr. Your name is not on the screen, so I forgot your last name. Jacoby, I forget your last name, sir, because your name is not on the screen.
I apologize for that, Mr. Chairman. Jacoby Whitley, JACOBIE, last name WHITLEY, and I'm present on behalf of the third party witness, Jacob Fuchs, who represents the landlord.
Okay, so you're here for the landlord, and so who's the landlord?
Jacob Fuchs is the landlord's representative, and he should be on the bottom left. Jacob.
Well, he's there, so can he come on and identify himself for the record?
Mr. Chair, how you doing? Thank you so much for your time today. My name is Jacob Fuchs on behalf of 1606 K Street LLC.
And so what's your relationship with that establishment? You said tell me what your role is, sir, for that establishment.
I'm managing member for the LLC that owns the property.
All right, fine. All right. All right, so Mr. Zhou, tell me what is going on from your perspective?
So the story is long. I'll start from the beginning. So starting last year or so, there was another medical cannabis licensee at 1606 K Street Northwest in Washington, D.C. That was ICE, and their trade name was Blanc DC. And in January earlier this year, there was essentially there was some rent dispute between Blanc DC and the landlord 1606 K Street LLC. And to settle that dispute, the parties signed the lease termination assignment agreement where Blanc DC agreed to vacate and surrender the possession of the premises and to transfer the license to the new tenant for 1606 K Street. And at that time,
what license?
I'm sorry, just 1 second. Let me pull it up.
Are you saying that they decided to transfer the cannabis license or the
Yes,
lease?
the cannabis license along with the lease. It was license number.
No, you don't need to give me the number. So
Okay,
I didn't. So you're saying that there was a dispute, and who owned the license?
Blanc DC owned the license.
So you're saying Blunt DC transferred the license to the landlord?
Not to the landlord, to the new tenant designated by the landlord.
But you just can't transfer a license. I mean, no one has a license until it's approved by.
I understand that. That's if I may continue the story.
All right, yeah, go ahead.
Yeah, so at that time, there was a power of attorney signed on behalf of ICE's owner, Mr. Chong Nak-sung, and the power of attorney was executed by his son, and the son there signed the transfer consent form. And then while the transfer process was going on, essentially, Mr. Chong Nak-sung decided not to transfer the license anymore. And then there was a lawsuit, and the lawsuit is still pending until today. I think the board probably have seen the lawsuit that's appeared on board agendas before. And however, at that point, I mean, to today, the lawsuit has been pending for a long time, and hospital did not get the license, and the landlord could not collect rent, and in the end, to have a damage mitigation efforts, the landlord started seeking new prospective tenants, and now here we are. That's District Reserve LLC. This is a new company here that's we acquired the license. We're trying to acquire the conditional license from Given Tree, and then put that license here, the 1606 K Street Northwest. And then around 2 months ago, we submitted a transfer application, but also the permanent license application on behalf of District Reserve LLC. And at the moment, we do not have a lease with the landlord. However, we do have a letter of intent with the landlord to have negotiate a lease 1606 K Street. And at this moment, I think it might be more helpful to have the landlord attorney to tell their side of the story as well.
Well, but all right. If I'm following correctly,
yeah,
Blunt DC had a conditional license.
No, they had a full license.
They have I'm sorry, Blunt DC has a full license. And that there was a dispute with the landlord, and allegedly, based on that license was turned over to the landlord.
No, it was not turned over to the landlord. Before any transfer process could be completed to the new tenant, the owner there for Blanc DC put the license into safekeeping.
Right.
Yeah.
So what license are we? What license is it that is in play?
So that was just for the background story. That's actually now the license in play right now for District Reserve LLC. The license in play right now is a social equity conditional license from Given Tree. The license number is 127885.
All right, so Even Tree has a conditional license, and so they're trying to move, and that's Miss Ballard and her partner. They're the ones who own the license for Even Tree.
No, they do not own the license to Given Tree, but Given Tree signed the transfer consent form to transfer the license to District Reserve LLC, which Ms. Ballard and Mr. Nasser own.
It's not supposed to be this complicated. All right.
I agree with that.
All right. So all right. So Mr. Whitley, right? Mr. Whitley, do me a favor. Just when you okay, thank you. Mr. Whitley, now your name is there. So you represent the landlord.
Yes.
All right, so there's no lease. So there's a letter of intent, but the previous, from the landlord's perspective, just tell me.
Yeah.
Go ahead.
Yes, Mr. Chairman. So from the landlord's perspective, there's no lease with Blunt DC. That lease was terminated, right? And the license that was associated with DC has been placed in safekeeping, right? There was an attempt to transfer the Blunt DC license to Half Smoke, but that transfer was denied. And because that transfer was denied, Half Smoke is also not a tenant of 1606 K Street. So Blunt DC is not a tenant at 1606 K Street because they terminated their lease. Half Smoke is not a tenant at 1606 because they were not awarded the Blunt DC license, and so they cannot execute their lease, and they're not a tenant. So the space is unoccupied. And now there's a letter of intent with District Reserve, the current applicant for this hearing, and they're trying to transfer the conditional license that's held by Giving Tree over to them. And once that process is done, they would like to move into the space at 1606 K Street. And there's not a lease right now with them because of all the background, but there's a letter of intent, and the landlord intends to lease the property to District Reserve, who's the current applicant.
All right, so Mr. Zoe, does District Reserve, what type of license do they have an actual license?
As
Or
of right,
conditional license?
as of right now, no.
And so what licenses DC Reserve trying to get?
Given Tree's social equity conditional license. For medical retail, medical cannabis retail.
And who owns Even Trees? Who are the owners of Even Trees license?
As Mr. Kevin Murray is KEVINMURRAY.
So he wants to transfer that license to Even Tree, right?
He wants to transfer that license to District Reserve LLC.
All right. Okay, so he wants to transfer that license, but we don't know whether or not your client would even qualify for a license, or would they even qualify for a license?
My client here, District Reserve LLC, should qualify for a social equity license to fit the criteria.
But I'm just saying, we're the ones. It's this agency who decides.
Yeah, absolutely.
The person qualifies for the license. So all of this is up in the air, in a sense that one Even Tree needs to transfer their license to District Reserve, which is your client, and where we are is that District Reserve is saying that they have a space that there's an intent, so if the licenses transfer, and this is a conditional license or is this a standard license?
Right now it's still conditional.
It's a conditional, well, it's conditional until you have until you have a
permanent license.
location.
Yeah.
And so you folks have I have to be on my toes this afternoon. I just can't just sit here and just wing it. All right.
Well, thank you, Mr. Chair.
Yeah, I'm hoping that other board members are taking notes so they can ask questions. But so let me ask. So for the record, this is for District Reserve. Then they're gone from the. Can you guys come back, please? I think I see Monet Ballard, like the two people who are in the car.
Yeah, we're here.
All right, well, you're off camera. So
Uh-huh.
you two are I guess you and I'm sorry, what's the other owner's name? Miss Ballard and Mr.
Nasser.
So Miss Ballard and Mr. Nasser are the owners of District Reserve, is that correct?
Yes, there's a third member as well. The third member is not present today.
Well, who's the third member?
Miron Nicolas.
Myron Nicholas.
Myron Nicolas.
Can someone spell that for the record, please? So
Yes, the first name is Myron, last name Nicholas, Nicholas.
So are the owners separate and apart from a management team, or is there a management team in place for Reserve?
There's no management team. The members directly manage the business.
All right. So who's making legal and management decisions for the business?
Miss Ballard.
Miss Ballard. So can you tell me what's the business model that they intend to what's the business models? Anyone can answer.
Are you asking me?
I mean, either you or your attorney, ma'am.
Yeah. Do you want to go, Monet? Or I can go.
You could tell them.
Okay. Yeah. So Ms. Ballard and District Reserve LLC intends to operate medical cannabis retail business in DC, and the main type of business will just be a brick and mortar storefront, direct sale to patients in the district. We're not seeking additional endorsements or such as delivery or safe use treatment facility or summer garden. It will be a straightforward storefront medical cannabis retail.
All right, so what type of products do they plan to sell?
So my client plans to purchase flowers, pre-rolls, edibles, vapes, essentially all available products that are produced by DC cultivators and DC manufacturers.
All right, so where are we in the process? So where are we? Say if the board was to, where are we?
So right now we're negotiating a lease with the landlord, and in terms of the build out, there's really not much to be done because the previous tenant here was already a licensed medical cannabis retailer. So the space, the security features, everything was approved by Mr. Peru, and of course we'll invite Mr. Peru back again before license to see if there's if anything needs to be updated in terms of the security features such as cameras, safe. POS system, access control doors. But right now the focus is on the lease and to get the ANC process moving forward.
All right, so I know there's an intent. So either yourself or Mr. Whitley can tell me what does that mean? What does the lease process consist of? Tell me what does that? What needs to be done?
So what we mean by the letter of intent, that's just a good faith document that says that they intend to execute the lease and the landlord's not going to shop the lease to anyone else, right? and the right of first refusal to execute a new lease is with District Reserve, and the landlord desires to execute a lease with District Reserve, but they're just waiting on, they could do it now, but business-wise, they would like to do it when there's a little more clarity as to whether District Reserve will end up with the license. But they have all intense desires to execute the lease with the District Reserve.
Yeah,
All right,
on the
so
tenant side, I'm sorry, Mr. Chair, just one more point from my side.
no, go ahead, sir.
So on our side, as soon as we can receive the placards from the agency, we'll be executing the lease pretty much based on the letter of intent terms that we provided to the agency.
All right, so Blunt DC is currently licensed at this location, or is that so?
No, to the landlord's understanding that the termination for the lease for Blunt DC has been terminated. And we believe that's part of the reason why the owner of Blunt DC placed the license in safekeeping. So currently, the landlord's position is that the Blunt DC license is in safekeeping and it is not associated with an address because it has terminated the lease at 1606K prior to placing the license in the safekeeping.
So explain to me this termination process. Explain to me, you said it's been terminated. So what does that mean?
Okay, so Blunt DC and the landlord have executed a lease termination agreement, right? And that agreement terminated the lease, and they have fulfilled the most of the terms of that termination have been fulfilled. But that's where the issue came up with Blunt DC and Half Smoke, because part of the negotiated termination was one of the terms was that Blunt DC would transfer or assign their license over to whoever the landlord designated, and the landlord designated Half Smoke. But Blunt DC vacated the premises, but they never transferred the license to Half Smoke. Instead, they placed the license in safekeeping. Then what they did was the power of attorney that was used to facilitate some of the negotiations was later then revoked. And that is why, or that was the decision on why the board did not transfer the license to Half Smoke, because that power of attorney was revoked. So Blunt DC's license currently sits in safekeeping, not associated to an address.
All right. So this termination agreement is this in writing?
Yes, absolutely.
Has this information been provided to our agency?
Yes, I believe so. I believe Attorney Joe sent it in as part of this process.
So, but what is being so what is it that's been challenged in court? Is it the termination of the lease or the transfer of the license? What is it that's been what's been challenged in court?
The transfer of the license.
The transfer
and
of the
fairness,
license. Go ahead.
well, the promise to transfer the license, right? Because that's what was promised. Like you said, Mr. Chairman, you just can't arbitrarily transfer a license between parties. ABCA does that, right? And they make that determination. So there was a promise to transfer the license to Half Smoke. However, that transfer did not occur. And so the lawsuit particularly relates to damages that were incurred because the Blunt DC license was not transferred to Half Smoke.
But all right, so assuming arguendo, you go to court and the judge says that the license has to be transferred to Half Smoke. Okay? Does Half Smoke have a lease to operate in this space?
2 points, Mr. Chairman. No. Because the lease has been terminated, Half Smoke does, and because they didn't receive the license, Half Smoke does not have a lease at 1606 right now. And also, as far as the court, the court left the decision on who the license would be transferred. They left that to ABCA because the court felt as though ABCA had the authority to make that decision and not the court. So now the parties in that litigation have to deal with ABCA's decision not to transfer the license to Half Smoke, but the court is not going to undo that decision, and that is not what the case is about. The court is going to defer to ABCA's decision not to transfer the license to Half Smoke.
But irrespective of what decision is made by the court, there is no active Blunt, DC, or whatever entity does not have an active lease for this location. Is that correct?
Correct. There is no tenant. Yes, correct.
Now, would the court, do you know, is this a possibility that for the court to ask Blunt DC to surrender the license to the landlord or some other person, or I guess what I'm trying to find out. So, yeah, so you're saying the court has left and I think that's part of the confusion is that so the court will under and you can let me know, is it a possibility that the court would explain to me again one more time, is the court saying that what is the court saying? That ABCA will determine who the license can be transferred to, or is it that the license cannot be transferred? That's the part that and I think for the agency and for myself is what is it that the worst case? What is it that the decision can be made as far as the license?
From Half Smoke's perspective, the worst case has already happened. ABCA has made the decision not to transfer the license to Half Smoke, and the court has deferred to that decision. The court has already opined that they don't feel it's proper to involve itself in something that ABCA has clear authority over, and that's whether the license is transferred or not. Right. And so the court is completely hands off on that decision. And to my knowledge, I know the landlord is not asking the court to overturn that decision. And we're not looking to appeal that decision or anything like that.
All right. All right. Now, if Mr. Zoe is your client, are they able to get the required permit, like a certificate of occupancy, in their name at this location?
Yes, the certificate of occupancy process for this address actually should be quite straightforward because there was a reason why I believe from 2025. So we only need to submit a change of ownership certificate of occupancy that shouldn't take more than a month.
All right. So what step What steps, if any, has your client, have they hired any employees as yet? That's just you, Mr. of your reserve DC. Have they hired any employees or what is
No, yet.
what's going on with their business?
No, yeah, we're all we're trying to do here is to see if the board will grant the placards to District Reserve LLC. Once that happens, we'll form the lease. We'll hire architect to start the certificate of occupancy process. We'll start working on the basic business license prospect. We'll start engaging with the ANC, but all the efforts now are contingent if the board will grant the placards.
All right. So tell me about ownership. What experience, if any, does ownership have in this business, the business of cannabis?
That might be easier for my clients to answer that question.
Miss Ballard, Mr. What is your training background in cannabis?
So not specifically in cannabis, but with tobacco shops, beauty supply stores. We have experience in retail in different locations across the nation. We got into or caught interest with cannabis industry. One, because of the opportunity that it was given with the conditional license, and just doing the research. I also did take the course for the cannabis, so learned a lot there, but hands-on, not very much. We'll learn as we go along.
So what course, ma'am, did you
The
take?
ABCA course.
The Green Culture Ad.
So you took but is it the intent to hire a management team, or is it the intent that you guys, without any direct experience in cannabis, I know that yes, you have experience in business based on what you're talking about, but
Yeah, no, the intent is definitely to hire a management team and also be there to learn and figure out, each aspect of what needs to go on through the management team, for sure.
So let me answer a question. Does the current ownership understand that they can only distribute, store, and sell medical cannabis products provided by DC licensed cultivation centers and manufacturers?
Absolutely. I learned that through the ABCA course. So yes, we understand that.
Does the business have any Schedule I substance in its possession, either on-site or another location?
Can you repeat that?
Does the business have any Schedule I substances in its possession, either on-site or at another location?
No.
Does the business have any non-medical cannabis products in its possession, either on-site or another location?
No.
Does the business understand that the presence or distribution of Schedule I or non-medical cannabis products may lead to the closure of the business or the revocation of the license if it was granted?
Yes, sir.
Okay. Any questions by the board members? Go ahead, Ms. Quinn.
I still I'm confused about this ongoing litigation, because on the one hand, we're hearing that the court is deferring to ABCA, but on the other hand, there's this. It seems that there's still a proceeding where the court is deciding who's at fault or what damages are due for the lease not being transferred. And those two things don't really match to me, because if the court is saying that it's up to ABCA fully to decide whether this lease can be transferred, then how could you hold one party accountable for damages associated with the lease not being transferred?
Ms. Quinn, if I may, so the court there, its main focus will be on the monetary damages side. Like say, for example, because the license or the lease was now transferred, Half Smoke incurred certain damages, for example, lost business revenues, um, um, lost goodwill from other businesses, from the customers. And on the landlord side, we're arguing that this is a direct causation. The landlord could not collect rents for a long time. It's because of the unwillingness to transfer the lease or the license. So it's that's one major aspect when we talk about the damages in court. They're mainly monetary damages. Yes, Half Smoke is asking for a specific performance to have the court to force SK, the Blanc DC, to even voluntarily transfer the license. But as we understand, the court, when it uses the language, say, defer that decision to ABCA, understand that the agency has its own involuntary transfer process, like on the alcohol side. So that's what it will look like if the court eventually orders a specific performance as part of the judgment.
Say that last part again.
So if the court orders a specific performance as in involuntary transfer as part of the judgment in the end, ABCA itself, the agency itself, as I understand, has its own process to do the involuntary transfer. So the court is not wrong for saying, we defer to ABCA for the transfer process. Either way, we have to come back to the agency for either voluntary transfer or involuntary transfer.
Yeah, it's
It's not just you, Miss.
So I would just add,
It's
from
just not you, Miss Quinn. It's not just
Oh,
you.
okay.
so I would just add from the landlord's
I'm sorry,
perspective.
Mr. Whitley. Just state who you are, because remember we're
I
recording
apologize.
when you're speaking each time. Yeah.
Yes, Jacoby Whitley, on behalf of the landlord. Chairperson Quinn, I'm sorry, board member Quinn, I apologize. The landlord, and I believe Half Smoke, I think one of the principal claims in the lawsuit is tortious interference with contract, right? And so that's what the damages are based on, right? And the fact that specifically in the ABCA's determination, they found out that the license was not transferred to Half Smoke because Mr. Sun revoked the power of attorney um, that he used to help facilitate these transfer previously, right? So the liability doesn't have anything to do with it. ABCA is whether Mr. Sun's act of revoking that power of attorney was in fact tortious interference with contract. And it's like ABCA has already settled that. So that information is just going to be used in the lawsuit, but we're not relying on an ABCA decision, or I know the landlord's not asking for a specific transfer of a license, right? And from my understanding, that's why the court deferred the transfer section to ABCA. And I would just also add that also the landlord is also just suing essentially for breach of contract, right? For non-payment of rent. That's what led to lease termination. It was Blunt DC stopped paying rent, right? And so the landlord came together and was like, all right, can we set up some type of way where you get released from the lease so you don't just incur this non-payment of rent and the arrears just goes out of control? Can I mitigate that by negotiating a termination of lease? And part of that was, well, since you have a license, will you be willing to transfer that license over to the tenant, being the landlord, that the landlord designates, right? And then that's the part that fell apart. And we had the power of attorney transfer, then a power of attorney got revoked. Then that would lead to the tortious interference claim and the breach of contract for non-payment of rent.
Okay. Was this just a poorly written agreement in the sense that, I mean, did it say that this party was obligated to transfer the lease, or did it say that you're obligated to participate or, help facilitate the transfer of the lease?
The latter. Help facilitate the transfer of the license to SK. Yes.
Okay. So one last question, or I hope one last question on this ongoing proceeding. What I heard someone say something about Half Smoke is still pursuing actual performance, which I think would mean trying to figure out how they can get the lease transferred. Is that accurate?
It's partially accurate. So we're still I'm sorry, Yu Tongzhou speaking here. We're still seeking well, since I'm also half Smoke's attorney, so we're still seeking specific performance. This performance is not to have the lease transferred, is seeking to have first of all the monetary damages that was incurred because, well, two things. One, there was 4 years interference with Half Smoke's business expectations of having the customers and having a relationship with other, say, for example, vendors or other type of third parties. That those business relationships were severely interfered because the license was now transfer was put back into safekeeping. And the second part of that, the specific performance that you mentioned, it is a extraordinary and rare remedy that the court gives. But if it happens, the best case scenario would be the license that is in safekeeping will be transferred to Half Smoke, which will still remain safekeeping and without a location.
So are you representing them in the appeal?
In the Superior Court, yes.
So you're in one court asking for the license to be transferred to your other client, and then you're here asking for a license for this client.
For another client, yes. My clients have signed the conflict waiver for me, so.
That's it for me.
Go ahead, Mr. Turner.
Assuming we didn't have the complications that my colleague brought up, if this were a new application, is it correct that your client has limited experience in the cannabis industry, does not have a lease on a property, does not have any permits or approvals, and I didn't hear anything about a plan to staff with knowledgeable people to manage and operate this business. Is that correct?
Well, good afternoon, Mr. Turner. I would say that's partially correct. So first of the second 2 questions will be a little bit easier because right now we want to make sure that we can get a placard before we have any expenditures to hire a management team that's knowledgeable in cannabis, and before we hire employees, and also before we hire an architect to transfer the certificate of occupancy to District Reserve LLC's own name. Is because, well, if the board were to decide not to grant the placards, all the money will be wasted. It will be for nothing. And as to the experience, well, as my client has conceded there, yes, there's limited experience. However, those experiences, I will argue, can be fairly easily gained with the metric training, with Green Culture Act training, with various type of programs that ABCA provides, with participating in the quarterly stakeholder meetings, and also just by being in the industry itself, meeting other retailers, cultivation centers. Since this is a pretty, from my experience here, it's a very closely held community that people tend to know each other, people teach each other different things. And also, well, special shout out to Investigator Peru here. Mr. Peru has provided numerous clients of mine with a lot of guidance and advice. I'm sure Mr. Peru will provide District Reserve with necessary guidance and compliance guidance as well.
So just to build on that, you're here to seek a placards, and then you'll get about setting up a business.
Yes. And as we understand, this type of fact-finding hearing usually happens after the placard process, after ANC settlement, and before approval. So if the board would like to set another fact-finding hearing and to see how much knowledge or experience my clients gained in the meantime, and our certificate of occupancy progress or basic business license progress, we can do that too.
Thank you, Mr. Chair.
All right. Any other questions by any board member? Go ahead, Mr. Meadows. Mr. Turner, put your hand. Both Mr. Turner and Mr. Meadows.
Mr. Zhu, good afternoon, Mr. Zhu.
Good afternoon, Mr. Meadows.
When did District Reserve apply for social equity license?
Let me pull it up here. Just 1 second.
And while you look at that, were you saying giving tree or even tree?
Given tree. So we submit.
GIV.
Yeah, given.
Okay.
So given. Yeah. So we submitted application on June 15th, 2026.
Okay.
Yeah.
And they're all right. I'm not a lawyer, so to me, the lawsuit, the appeal, I understand that that can continue. The way I look at it is Blunt DC has a license in safekeeping, and District Reserve is trying to get their own license separately.
Correct.
Thank you.
Thank you.
Any other question by any other board members?
I do have one closing point.
Go ahead, Mr. No,
Chairman.
I'm not done yet. Go ahead, Mr. Whitley.
Okay. I would just add, and this is piggybacking or circling around to board member Quinn's point. It's the specific, I don't represent Half Smoke, so those aren't my claims, right? But let's just say in some world, let's game out the hypothetical if some type of way Half Smoke was to end up with an order to receive the license, right? As board member Meadows just highlighted, the Blunt DC license is in safekeeping and not associated with an address. So if Half Smoke were to receive that particular license, which is different than the license that we're talking about today, if they were to receive it, they could still open it and use it at a different address. The address has to be vetted by ABCA. So it's not like if they received it, there's nothing that they could do with it. And they just end up with the empty license that they can't operate. They can operate at a different spot, not at 1606 K Street. And I think they have prepared themselves for that reality. So I don't know what, points go into your guys' decision, but because I don't know, I just wanted to highlight that point.
Yeah, now let me put on the hat of attorney for Half Smoke. So if we were to get that license from the court judgment, we'll try our luck and find another location in the district to open up that location. We would not be 1606 K Street anymore. This expend too much money for this efforts, and those group of clients will call it quit for now. So.
You have answered one of the questions that I had, Mr. Zoe, about Half Smoke. And thank you, Mr. Whitley. Maybe you saw the question on my forehead. So thank you, Mr. Whitley, because the question was Half Smoke, was it their intent to move into 1606? And so as far as Half Smoke is concerned, their intent is not to move into 1606. But I guess another question is that part of the incentive for Blunt DC to give up their space was, one of the conditions was to transfer the license as part of the condition. So if the license was not, how can you state that the license is terminated if one of the tenets of the termination is that they were supposed to give the license? So how are we being told that a license terminated if a significant portion, a significant factor has not been complied with for whatever reason?
Great question, Mr. Chairman. So it's the language of the termination and the release. So the transfer of the license wasn't the only triggering event. The main triggering event, as far as the landlord was concerned, to release, the triggering event for the landlord to release Blunt DC from the lease and to terminate the lease, that triggering event was based upon Blunt DC paying the landlord a set amount for liquidated damages. And Blunt DC paid the landlord that. So the landlord is obligated to release Blunt DC from the termination, right? But there were like ancillary documents. And in the culmination of the ancillary documents, that's when they said or included, that's a separate and apart from the lease termination. It's like I I can't remember the name of those agreements, but they're ancillary documents, and they game out, hey, Blunt DC, we want you to work with ABCA to transfer the license to um, whoever the landlord identifies. So, because of the drafting of the termination, the release from the lease was triggered by Blunt DC paying that set amount, and not triggered by them actually giving the license to that new tenant. So Blunt DC fulfilled their condition precedent to be released. And because that language in that section, the release section, did not include or talk about the transfer of the license, we feel as though they have met their obligation and the landlord was required to terminate their lease.
Um, um, Mr. Whitley, and I guess what from your perspective, at least from your, since you represent the landlord, are there any arguments being made by Blunt DC in court, in any of their court filings, that they have a right to that their lease at 1606 have not been terminated?
Ooh, I don't think so, Chairman. But to be honest, I cannot recall that specific detail off the top of my head. But I don't think so. But go ahead, Mr. Joe, if you
Yeah,
know the
Mr.
answers
Chair,
to that.
if I can chime in here. So back then when we had the whole briefing in front of the board for the declaratory order for Blonde DC and Half Smoke and all that matters, I believe that Blonde DC's APCA counsel, Mr. McGowan, actually emailed Mr. Berman that the said 1606 being the former address of Blonde DC. So part of the email will concede that they no longer occupy the space. They are not contacting that point.
I guess Miss Ballard, I mean, why when we have these fact finding here, and I like to see people. I mean, I know that I know you have your attorneys and you're paying your attorneys to speak for you, but you're here. I don't understand why you're not on camera. I want to make sure.
I believe your IT team did that because everybody was on camera and then it all just blinked out and went to the, but I got it. I can put it. There you go.
Yeah, ma'am, you're on. Thank you. All right. So let me ask those questions. And either I guess it's you from you, Mr. Zoe, from you and your client. So, what questions need to be settled for this matter to be resolved?
You mean for district reserve's application?
Yes.
I think the central question was that if Blonde DC's license still is associated or attached to 1606 K Street Northwest. If it is not, then I don't see a thing that should block our application. I think that is the most central question to these two applications. Well, I mean, the half smoke applications are denied, so only to district reserve LLC's application.
Is it possible for you, Mr. Zoe, to do another declaratory order request to settle whose application should be taken up?
I'm sorry, Mr. Chair, I don't think I understand the question.
No, I said, I think the issue that the board has is that, as are the agency, as far as we're concerned, there is another license. There is a lease for a license at that location.
Oh, I understand.
Mr. Board, Mr. Chairman, this is the landlord. There is no lease with Blunt DC. They
Okay.
do not, they have given up possession of the property and there is no lease. So their name should not be part of this conversation today at all. With all due
Okay.
respect. Because we
Well,
keep going back to that about Blunt DC. Blunt DC has a terminated lease from January of this year and has given up possession of the property.
thank you, sir,
I just
for-
wanted to clarify that point as direct as possible for everybody here, because we keep circling back to that.
But no, but it is as I said before, but not for the fact, as you're aware, that we can't have a license within 400 feet of each other, another license, and the issue is that we have someone asking for a license at a location, and we're being told that there is an active lease by some other entity for this location, and so therefore I'm trying to get clarification to say that no other cannabis entity has a lease at 1606.
They do not. And Jacoby, please clarify that is correct as well as my legal counsel.
Well, the bottom line, sir, I mean, your attorney can only speak for as what's represented by the client. The client is here stating what the position is. So I mean,
Blunt DC and SK Corporation does not have a lease at 1606 K Street.
Okay. Now, all right, so let me ask you a question. Mr. Whitley, are you able to provide this board with either a court order or whatever it is you can provide to say that Blunt DC has no rights to 1606 because there is no lease? And that's what I'm because Blunt DC is not here. They're not here today, and we're not involved in the court proceeding. And each side is making representation, but the other side is not there. Blunt DC is not here, and so they might say, "Oh, no, we still have a lease. From our position, we still have a lease, and we're waiting for the court to tell us. So, is there any court order or any order that basically says that the lease has been terminated? That
So-
there's no Mr.
Mr.
Jacob.
Chairman, sorry.
Yes.
If I'm correct, and Jacoby and Mrs. O, the suit was brought against SK from the landlord, correct? Not the other way around.
Correct. And also, I will add that in the beginning it was Half Smoke that sued Blanc DC, and then the landlord joined as an intervener. None of these actions was first occurred in the landlord-tenant branch of the Superior Court. This
And-
action took place in the civil actions branch, so there was no possession in question. That's why none of this action was brought in landlord-tenant branch.
Correct. And SK
Chairman,
and Blunt
to answer your
DC,
question,
Hold on, let Mr. Jacob finish, then you can go ahead, Mr.
if I'm correct, SK and Blunt DC did not bring the suit against us for possession of the property. So Jacoby, please jump in.
Mr. Whitley, go ahead.
yes, I was just going to add, Chairman, as things are being articulated, is yes. So the landlord is a plaintiff, and Half Smoke is a plaintiff against
Blunt
DC,
Right.
right? and they are suing for the tortious interference and things of that nature. Now, no, I'm certain that Blunt DC has not filed any type of motion or any filing or counterclaim saying that they are still in possession of that property, right? And the only order, or they want access to the property, or they have any rights to that. That's why the order speaks to the deferral to ABCA regarding that transfer. So the order doesn't speak to whether the lease with Blunt DC is still active, because that's not a question that's been presented to the court, and that's not a question that the court has been asked to resolve. And so, what I can produce is the termination of the lease that has been signed and executed by the landlord and also Blunt DC, and I think that's already been submitted, is already in evidence with the board.
Well, I'm not sure, but so why don't you send that
Sure.
document to
Yeah.
ABCA Legal? Send that document
Yes.
so we can issue a declaratory order to state that Blunt DC does not have a lease at 1606.
I can do that.
All right, so you send that to us. So the issue of so, and this is it's irrelevant who at this juncture, who, whether or not it's Half Smoke, whether or not it's Blunt, if who has the license, but as long as as long as we get something to state that Blunt DC has terminated, that the parties have terminated their lease, and so there is right, then that should
Yes.
then the board, at least we can, that will make whatever decision that needs to be made much easier, because we are now having writing that there's no lease in place for this location, and so therefore Reserve DC can provide us their intent to lease, and that would be, of course, a valid document, because it's not just, there's no other party who can now come and state that I actually have a lease.
Yes.
All right.
Yes. And did you want me to also include the letter of intent in the same email so that you guys have the termination?
You can provide. I
Okay.
think we have that, but you can just for
Okay.
our record, to close the loop, you can send that information to us. To
Certainly.
ABCA Legal, we will review that and try to figure out where we go from there. Is there any final comments that you want to make, and then I'll end up with you, Mr. Zoe?
No. Thank you for your time. But no, I have no further comments.
All right, Mr. Zoe. Any further comments? And I guess what is it that, from your perspective, just tell us what it is that you want the board to do.
We want the board to issue the placards for district reserve policy.
All right.
Yeah. But yeah, thank you, Mr. Chair.
All right. We will take this matter under advisement, and we will issue a decision. I believe that there's probably another order that will come out, but we'll take this matter under advisement. And it is not supposed to be this complicated. It's just a license. But
Mr. Chair,
I guess,
as you know, Jacoby, Mr. Wisley and I have worked with the agency for many times for many licenses. We both said this is by far the most complicated transfer process or new application process ever. So.
All right. Thank you for your presentation, Miss Ballard. I don't know if
Yes, thank you so much for hearing it. I'm listening to all of this, and I'm just like, it got me like, what in the world did I get myself into? But because I'm hearing a lot about, I guess what was going on before we entered the picture. But I do appreciate it, and thank you.
All right. The board will take this matter under advisement. Thank you for your presentation today. Have a great day.
Thank you, Mr. Chair. Thank you, board members. Have a good day.
All right. Bye-bye. All right, so let's move on with our calendar. The next case in our calendar is case number 20. Well, before I do that, let me call this case. Case number case number 26 CMP 00010, Cloud One Restaurant and Lounge, license number 130269. This case has been continued to September 23rd at 10:30 a.m. All right, the next case in our calendar is case number 26 CC 00001, District Cure Dispensary, license number 127161. Mr. Oriana, can you please elevate the parties in this case?
Good afternoon. Meredith Kinner, access elevated. Abel Gebre, access elevated. Chris Southcott, access elevated. That is all, Chairman.
All right, thank you.
Yep.
All right, can I have everyone on camera, please? Sorry. All right. So, Mr. Southcott, can you please identify yourself for the record?
Good afternoon. My name is Chris Southcott. First name Chris, last name Southcott from DC's Office of the Attorney General representing the district.
Good afternoon, sir. Ms. Kenner, can you introduce yourself for the record?
Yes, good afternoon, Chair Anderson. My name is Meredith Kinner, MEredithKinner, on behalf of the respondent, District Cure. The owner of District Cure, Mr. Gebre, is here today.
Mr. Gerber, can you please spell and state your name for the record, sir?
Hi, my name is Abel Gebre, ABELGEBRE.
Good afternoon, sir. Okay, so this is a full show cause hearing. And so, Mr. Southcott, are there any preliminary matters in this case?
No preliminary matters. I will note that the parties submitted joint stipulations of fact, I believe yesterday. My intention was just to, as the government's case, read those into the record, but I would like to have an opening statement before that.
Oh, then that's it. That's why I asked you. There is a preliminary matter. So I guess what I'm trying to find out from you, what is it from, because I'm aware of the stipulation that was submitted. So what is it how is it that this case should move forward today?
I believe that we'll still have a hearing. The parties intend to, as you'll see, the facts aren't necessarily contested as with respect to the violations. The parties are mostly going to be speaking about what the appropriate penalty is. But I did just want to, have the opportunity to provide an opening statement, and the district's case will just be reading the stipulations of fact into the record.
All right. Okay. So, Ms. Kinner, from your, are there preliminary matters from your perspective, ma'am, that needs to be addressed?
Just the fact that the first charge in the notice of show cause, we would like to move formally for dismissal, being that it's our position that it's redundant and encompasses the other two charges, encompasses charge 2 and 3.
Mr. Southcott.
So the district's position on this is that the first charge is not redundant. That charge is for dispensing medical marijuana to someone other than a qualifying patient. And that charge happened on two occasions on both January 5th and January 8th, when the undercover was able to purchase those products that the undercover was not a qualifying patient or caregiver. Those are distinct from the other charges. So charge two was for failure to for dispensing medical marijuana to someone who failed to produce a valid card. So on that buy, this occurred on January 5th, where the UC was asked for a medical card and said that he did not have one, and the establishment still sold it to him. And then charge three is the failing to take steps reasonably necessary to ascertain whether a person is a qualifying patient or caregiver. This relates to the conduct on January 8th, where the establishment never asked the UC for a medical card at all, and despite that, still. So the first charge relates to selling at all to someone who's not qualifying. Charges 2 and 3 deal with the establishment's responsibility to ensure that if they are selling, they need to check for the ID cards, or if someone does not have an ID card and identifies that they do not, then the establishment should not be selling to them. So the district believes that these are all distinct charges.
Well, I guess what we can do, Ms. Kinner, in your presentation, whatever presentation you're doing, you can argue why you believe that charge one and charge two are the same, and then the board, since there's no agreement between the parties, we'll take.
Yeah, that's fine, Chair
Oh.
Andy.
Okay, all right. So, okay, that's fine. All right, so, the government has a burden, so where are we, Mr. Southcott?
I'd like to proceed with opening statements, and after that, the government will move on to presenting its case, which would be the stipulations.
Go ahead, sir.
Mr. Chair and members of the board, licensed cannabis retailers are put in a position of trust by this agency. They're selling substances that are oftentimes can be adulterated and substances that are harmful to the wrong people who can consume them. And so to be a licensed cannabis operator is to hold yourself out as an establishment that the public and this board can trust to comply with the district's regulations that exist to provide district residents with regulated, safe, and tested medical cannabis. However, the evidence will show that District here has repeatedly engaged in behavior that violates the public's trust. At issue in the instant case are undercover buys, which took place on January 5th, 2026, and January 8th, 2026. Both of those buys were coordinated after ABCA became aware that there were complaints coming in that the establishment was selling medical cannabis products to customers who lacked a medical card, which then led to an investigation, which took place first on January 5th with the first undercover operation, where the UC was instructed only to make a purchase if products were available to unregistered cannabis patients. That UC was able to enter the establishment, was specifically asked if they had a medical ID card and said that they did not, and nevertheless was still allowed to purchase cannabis. In the process of doing so, the evidence will show that the cannabis was, the transaction was not sort of tracked in an ordinary manner, but was rather sent to an employee's Cash App account. Then similarly, on January 8th, there was a follow-up investigation where, again, an undercover investigator went to the same establishment, instructed only to purchase cannabis if products were available to unregistered patients. And similarly, they were sold cannabis products. But this time, instead of even asking for a medical ID card, the establishment, the employee who was working there at no point asked for a card or any identification from the individual that they are selling cannabis to. As a result, furthermore, while the transactions were entered into the metric system, the evidence will show that they were entered for incorrect patient information because there was no information that was provided, and yet there was patient information that was entered into the metric system. This causes, that has the potential to cause all sorts of harms to health and public safety of being able to make it hard to determine who properly has been sold cannabis, how much they have been sold, whether an individual has been oversold, or whether the establishment is properly tracking the individuals who are there selling cannabis to. Beyond that, these regulations exist to protect the health and safety of district residents. It is a health and safety issue that individuals are only selling to, or that rather that establishments are only selling to individuals who have medical cards, who have established a reason why they are receiving medical cannabis. There's a health and safety issue around making sure that metric is provided exclusively with accurate information to ensure that patients aren't oversold, to ensure that that cannabis is not being sold to someone who isn't a qualifying patient. All of these exist for a reason, and yet we have an establishment that has violated them and violated them repeatedly. And this particular instance is not the first time the district here has been before this board. There's a previous summary closure of this establishment when an undercover buy occurred, where the UC went into district cure and did not produce a medical card. And that district cure employee then, instead of refusing to sell, took that UC to a second floor of the premises and sold them unlicensed cannabis products. Now, at the time, the establishment argued, and this board said that, well, those were the actions of a rogue employee in that instance, and maybe that's the same that is happening here. Maybe it's also the actions of a rogue employee. But it is the obligation of this board to determine whether not just rogue employees, but whether an establishment and its ownership can be trusted to adequately supervise an establishment to ensure that its employees are complying with the health and safety regulations around the legal sale of cannabis. So ultimately, this question is whether the board can trust Mr. Abel Gabre, who's the owner of this establishment, to run a licensed cannabis retail dispensary that complies with the law. In its order in the prior summary closure, the board said that there is insufficient evidence to demonstrate that Mr. Gabre was acting with willful blindness. The district hopes that at the conclusion of this hearing, the board will find that there is sufficient evidence to demonstrate that this establishment is not trustworthy enough to retain its license, and therefore the district at the conclusion of this hearing will be asking for the revocation of this establishment's license.
Ms. Kennedy, you wish to make an opening statement?
Yes, I also wish to address Mr. Southcott's representations about the previous action that involved district cure. We did not stipulate to the facts there, and as far as the respondent is concerned, it is inappropriate to raise facts that are not part of this record here. We are here to talk about the violations that occurred on the 5th and 8th of January 2026. Okay, the board already adjudicated the prior instance that involved district cure, and I do not believe that Mr. Southcott should be allowed to introduce any information about that, any specific information about that instance, because it is not part of the record that we have stipulated to. He can say that it happened, but I think that referencing particular facts there is wholly inappropriate. That the board should strike any reference to the specific facts that were the basis of an earlier instance, which we are not adjudicating here. And then I wish to make an opening statement.
Go ahead, ma'am.
May I respond to that briefly?
Well, it's an adjudicated case. I mean, I think that the board, with the case in front of the board, we can review if it was an offer in compromise. I mean, the board can go review as part of the investigative history for whenever the board makes a determination. We can look at the investigative history of the establishment to see what it is that they were charged with, and so I think that's sufficient. I mean, I think that the record speaks for itself. So I mean, the record speaks for itself because the board, of course, the government is asking for revocation, and so therefore they're they can bring up what what occurred previously. I don't know what was in the offer and compromise.
Mr.
Yes,
Mr.
Mr.
Chair, may I speak briefly?
Yes.
All references to anything that occurred in the past, all of that comes from Board Order 2025-085, which was an order affirming summary action and denying request for revocation in the previous instance. So to the extent that the board is, using any information or any of my arguments are coming from that, it is from the findings of fact that this board made in that order, and the conclusions of law that the board made in that order. So all I ask is that the board consider what was previously discussed in that board order, including those findings of fact and conclusions of law.
And I would remind, if I may, I would remind the board that it shows that it ultimately found that none of the complained of instances occurred at the licensed premises. And my understanding is that that was why revocation was inappropriate in that instance, because my client Mr. Gebray had nothing personally to do with it, and they did not occur at the licensed premises. So again, we object to any reference to the specific facts in any earlier instance that involves district cure. I would like to make an opening statement if that's possible.
Go ahead, ma'am.
Thank you. Good afternoon, Chair Anderson and members of the board. The government has recommended that the board revoke District Cure's dispensary license on the basis of the charges in the February 3rd, 2026 notice of show cause. District Cure respectfully asked the board to reject the government's recommendation because it is unduly punitive. Revocation is the ultimate punishment, and it is only appropriate where the government can show that the licensee's conduct is so flagrant and egregious that it presents an imminent harm to the health and safety of the public. And that is clearly not the case here. The facts that we have stipulated to and the violations that we have stipulated to are as follows. District Cure is before the board today because on January 5th and again on January 8th, a former employee of District Cure failed to verify whether an undercover police officer was a registered medical cannabis patient before dispensing one joint to that UC. The former employee then entered each of these sales into Metric using an unassigned patient number. They did not oversell any patient. The district cannot show that that number was even assigned to a patient. That is why we're saying it is unassigned. They have not shown that anything has been oversold here. The government is recommending revocation on the basis of these facts and violations. And we are not here to dispute those specific facts or violations. In fact, we have stipulated to them. This hearing is to contest the disproportionate penalty that the government recommends for these violations. The standard for revocation is imminent danger, and there is no imminent danger here. In fact, District Cure has been open and operational since January 8th, when the last violation occurred. And as you'll hear from District Cure's owner, Abel Gebray, District Cure has operated without incident since January 8th, 2026. Mr. Gebray will also describe the steps that he took to remediate the conduct that gave rise to the January 5th and 8th, 2026 violations, including retraining District Cure's remaining staff and recertifying his personal patient-focused certification training. You will also hear that Mr. Gebray directly oversees District Cure's daily operations currently, and that he is personally committed to ensuring that District Cure remains compliant with ABCA rules and regulations at all times. Finally, you will hear about the detrimental effects that revoking District Cure's license will have on Mr. Gebray and his family. District Cure is a small business, and if the board were to revoke its license, Mr. Gebray will lose his job and his means of providing for his family. And he will still be responsible for continuing to pay the monthly rent at 2626 Georgia Avenue, where District Cure is located, as well as District Cure's other recurring monthly expenses. Revocation should be the penalty of last resort because it is the death penalty for a licensee. And so District Cure is really here to fight for its life today. Thank you.
I guess I just want to clarify for the record that charges, the parties are the parties in agreement that charges 2, 3, and 4 are admitted, and there's just a legal objection to charge 1.
That's correct from the respondent standpoint. Charge 1, we just think that the use of the term dispense there is really kind of encompasses both the other charges. And that's our position as to charge 1. But yes, you are correct. The remaining charges, and I would add, there is no specific, though it's mentioned in the recitation of the facts, there is no specific charge relating to failing to ascertain if a patient had a state issued ID. As far as that.
So let me ask you, if the board agrees with the government, is the licensee admitting to charge 1, or is it that you're just saying it's subsumed in another charge?
We believe that it's fairly encapsulated in charge 2 and 3.
Okay. All right. Go ahead, Mr. Southcott.
So for the district's case in chief, the district intends to read its stipulations into the record. So I just wanted to confirm that the board has received the joint proposed stipulations of fact.
We have, but again,
Okay.
you have to place it in rights. Yeah. Okay.
So briefly, I'll work through these. So paragraph 1, District Cure Dispensary / Natanem 2 Inc. The licensee has a medical cannabis retail license to sell cannabis products regulated by the District of Columbia Alcoholic Beverage and Cannabis Board, which is the board. 2, the licensee's registered business address is 2626 Georgia Ave, Northwest Washington, D.C. 20001. 3, around January 2026, Alcoholic Beverage and Cannabis Administration, ABCA, Supervisory Investigator, SI, Jason Peru received several complaints that the licensee was selling medical cannabis products to consumers who lacked a medical card. 4, on January 5th, 2026, SI Peru coordinated with an undercover ABCA investigator, UC1, to conduct an undercover operation at the licensee. SI Peru instructed UC1 to only make a purchase if cannabis products were available to unregistered cannabis patients. 5, that day UC1 entered the licensee's premises, where they were met by a female employee, E1, who asked for UC1's identification or ID. UC1 produced their driver's license. E1 asked UC1 if they had a medical ID card, and UC1 said, "No, I don't." E1 told UC1 that she would allow UC1 to purchase cannabis, quote, "this once," end quote, but that district law requires a medical cannabis card to purchase cannabis. E1 then admitted UC1 to enter the dispensary sales floor. 6, on the sales floor, E1 asked UC1 what they were looking for, and UC1 said they wanted a pre-roll cannabis cigarette to help with anxiety. E1 produced a bag of pre-rolled cannabis cigarettes, and UC1 selected one labeled, quote, "District Cannabis Gorilla Glue," end quote, that at a price of $19.08. E1 said that UC1 could pay via debit card or Cash App, and UC1 selected Cash App. E1 told UC1 to send the money to Iris Dagny, I apologize if I'm getting that name wrong, Cash App account. UC1 sent the money to the designated account, and E1 then handed UC1 the cannabis pre-roll cigarette. UC1 then exited the licensee's premises. 7, UC1 then met with SI Peru and gave SI Peru the cannabis pre-roll cigarette that UC1 purchased. SI Peru confirmed that the cannabis pre-roll cigarette was medical cannabis from a licensed medical cannabis cultivator. SI Peru booked and secured the evidence. SI Peru also confirmed that Iris Dag is an ABCA registered employee with registration number MCP-131696. 8, the licensee entered UC1's January 5th, 2026 purchase into the Metric real-time electronic record system. However, the entry did not include accurate patient information. 9, on January 8th, 2026, SI Peru conducted a follow-up undercover operation and coordinated with an undercover ABCA investigator, UC2, who was instructed to only make a purchase from the licensee if cannabis products were available to unregistered cannabis patients. 10, that day, UC2 entered the licensee's premises and was greeted by an unknown female employee, E2. E2 asked UC2 for their name, which UC2 provided. E2 then wrote down UC2's name and admitted UC2 to the dispensary sales floor. 11. Once inside, E2 asked UC2 what they were looking for, and UC2 said they wanted a, quote, Gorilla Glue, and, quote, pre-roll cannabis cigarette. E2 retrieved the pre-roll cannabis cigarette and told UC2 that they could pay $19.08 via debit card or Cash App. UC2 selected Cash App. E2 told UC2 to send the money to Iris Dagny's Cash App account, and UC2 complied. E2 then handed UC2 the cannabis pre-roll cigarette, and UC2 then exited the licensee's premises. 12. At no point during the transaction did E2 ask UC2 for an ID or a medical cannabis card. 13. UC2 then met with SI Peru and gave SI Peru the cannabis pre-roll cigarette that UC2 purchased. SI Peru also confirmed that the cannabis pre-roll cigarette was medical cannabis from a licensed medical cannabis cultivator. SI Peru booked and secured the evidence. 14. The licensee entered UC2's January 8th, 2026 purchase into the Metric real-time electronic record system. However, the entry did not include accurate patient information. 15. On January 5th, 2026, then January 8th, 2026, the licensee dispensed medical marijuana to someone other than a qualifying patient or caregiver when it dispensed medical marijuana to UC1 and UC2 in violation of DC Code Section 7-1671.05 et seq. And 22-C DCMR Section 5709.5. 16. On January 5th, 2026, the licensee dispensed medical marijuana to someone who failed to produce a valid medical cannabis patient card in violation of 22-C DCMR Section 5612.1 when it dispensed medical marijuana to UC1 despite UC1 stating that they did not have a medical cannabis patient card. 17. On January 8th, 2026, the licensee failed to take steps reasonably necessary to ascertain whether a person is a qualifying patient or caregiver in violation of 22-C DCMR Section 5612.2 when it dispensed medical marijuana to UC2 without asking for UC2's ID or medical cannabis patient card. 18. On January 5th and January 8th, 2026, the licensee failed to enter true and complete information into the Metric real-time electronic record system in violation of 22-C DCMR Section 5615.3 when it entered incorrect patient information into the system following the sales to UC1 and UC2. And 19, in addition to the case report and attached exhibits, which are automatically entered into evidence under 23 DCMR Section 1713.10, the parties stipulate to the admission of the licensee's exhibits number 1 through 5.
Just a clarification. I'm
Yes.
not sure if it was number 16. What was it? Is it number 16 or 15 you gave the dates?
The dates were listed in several in several of the paragraphs.
No, but the last, but I think it was 15 or I think in going through. I don't have it in front of me, and I thought you said January 6th, and I thought it was a different date. What was number 15? I'm sorry.
15 was on January 5th, 2026. And January 8th, 2026, the licensee dispensed medical marijuana to someone other than a qualifying patient or caregiver when it dispensed medical marijuana to UC1 and UC2 in violation of DC Code Section 7-1671.05 et seq. And 22-DCMR Section 5709.5.
And what was January? What was number 16? I apologize.
16 was on January 5th, 2026. Okay. The licensee dispensed medical marijuana to someone who failed to produce a valid medical patient card in violation of 22-C DCMR Section 5612.1 when it dispensed medical marijuana to UC1 despite UC1 stating that they did not have a medical cannabis patient card.
Yeah, thank you, sir. I thought I heard a different date. That's why I just want to make sure that we were all on the same date. Okay, that's fine. Thank you. Is that the government's case in chief?
This is the government's case in chief, and the district rests.
All right, thank you. Ms. Kenner, how do you plan to?
Yes, I would like to ask Mr. Gebre a few questions.
All right, Mr. Gebre, can you raise your right hand, please? Do you swear or affirm to tell the truth and nothing but the truth?
I do.
Your witness.
Yes.
Thank you, Chair. Mr. Gebre, what is your relationship to District Cure Dispensary?
I'm the owner of District Cure Dispensary.
And did you own District Cure in January of 2026?
Yes.
Are you the only owner of District Cure Dispensary?
Yes.
How many employees did District Cure, if you can recall, have in 2026?
I used to have 3. Right now, I have 2 employers.
Okay. When did you become aware of the violations contained in ABCA's February 3rd, 2026 notice of show cause?
When I heard about the showcase February 3rd,
And how did you hear about the notice?
when I received a paper from the ABCA,
And what did you do after you learned about these violations?
I went straight to the employer to talk to her about the incident.
And that employee would be the employee that failed to ascertain whether the patient was in fact a registered patient, or whether the individual was a registered patient?
Yes, I was asking her a question what's going on in that day. She's not able to explain for me. Then after I asked her that question, the next day she don't even show up. I never see her since that day.
And if she hadn't failed to show up the next day, had you planned to take any specific action regarding her employment?
Yes.
What did you plan to do regarding her employment?
Well, me and my other employer, we just take the training for a second time.
Okay, so the other thing you did after she quit was you retrained your other employees as well as yourself. Is that
Yes,
okay?
I trained my employers and myself too.
Thank you. And are you familiar with a patient-focused certification?
Yes.
I would like to show you, and I guess if I could share my screen quickly. Hold on one moment.
Mr. Oria, can you please allow Ms. Skinner to share her screen?
Access granted.
Thank you. And these are already in the record here. Can everybody see my
No,
screen?
ma'am, you're not sharing your screen.
I'm not sharing my screen. Apologies. Hold on one moment. Let's see. Okay. All right.
Okay.
This.
Okay.
So this,
go ahead.
Mr. Gebre, can you tell me what we're looking at here?
That's patient's focus certification.
Okay, and is that your name there?
That's my name.
And can you tell me what date you completed that?
I completed that 03/30/2026.
And that's it says here that it's valid for 2 years. Is that correct?
Yes.
Thank you. And I'm going to show you now Exhibit 4. Can you tell me what this is? If you can see it.
Can I see it? Can you make it like a little bit bigger?
Bigger? Yeah, absolutely.
That's the state law and regulation in Washington, D.C.
So are these other, just so I'm clear, are these other PFC training classes that you've completed? I see that your name is
Yes.
on the top here. Okay. And I've never taken a PFC class. So is this like is this a portal essentially?
Yes.
Okay. Thank you, Mr. Gebre. Let me stop sharing. Hold on one moment. And Mr. Gebre, have all of District Cure's current employees been retrained since the incident occurred in January 2026?
Yes.
And can you describe some of the training around ensuring that patients are in fact, or excuse me, that customers are in fact registered?
Yes, customer have to be registered to enter to the dispensary, and have to have a valid, proper ID.
And so if somebody doesn't present a patient registration, or you can't verify that they're registered, what happens?
We have to look their email have with a medical card and a proper government ID. If they don't have that, we don't allow them to get in a store and purchase product.
Okay, thank you. And who is responsible for managing District Cure's day-to-day operations?
I am.
Okay, and is it fair to say that as the individual and owner who's responsible for managing the day-to-day operations, that it is also your job to ensure that District Cure complies with all rules and regulations?
Yes.
And you already explained how you verify that somebody is a registered patient. Are you familiar with the metric system?
Yes.
Can you explain to me what metric is and what you use metric for?
Metric system is from the seed to the sales tracking system.
Okay, and what else does it do, if anything?
And we register a product when we receive from the cultivation, and inventory. Whenever we sell a product, is going to register to the system and a selling.
Okay, and does it also allow you to verify that a patient is registered?
Yes.
And how do you use, I guess, can you describe your kind of closing procedures and how you use metric?
Yeah, whenever we close the store, the metric system shows how many customers purchased the product, and we count the money, and if it's going to match, then we print out paper. We have every day we have a report that we work with the metrics.
Okay, and do you personally oversee those closing procedures?
Yes.
And since since January 8th of 2026, has District Cure been cited by ABCA for any other violations?
No.
And just to reiterate that since then, you have personally, as the owner, overseen all of the day-to-day operations of District Cure. Is that right?
Sure. Yeah, I'm always at the store working by myself because I was disappointed with my employers. I don't know why she did that. I don't know how that thing has happened. So I have to be in the store by myself.
And do you own or lease the location of District Cure at 2026 Georgia Avenue?
Lease.
And when did you enter into that lease?
I mean, I've been here on the store for 7 years, but since I have the dispensary, the lease starts June 2024 and expired end of July 2027.
Okay, so you have about another year left on the lease. Is that fair to say?
Yeah.
And what is the monthly rent for the property?
$2,000.
And if the board revokes District Cure's license, will District Cure still be responsible for paying the rent at the property for the remainder of the lease term?
Yes.
I'm going to object to this line of testimony on the grounds of relevance. If this is the true of any licensed establishment that is subject to this board's jurisdiction, that there are potentially leases that they are paying, and whether an establishment has a lease has no bearing on whether there is an appropriate penalty for it. If the conduct determines that a penalty is appropriate, then whether or not the establishment has a lease has no bearing or no relevancy on, or the duration of the lease has no relevancy on what the appropriate penalty should be.
Well, I'm going to overrule the objection. I think that there's stipulation of facts, and it's my understanding that the parties would be arguing penalty. And I think because the government is asking for revocation, I think it's relevant that they're saying the hardship that it would cost if the license is revoked. I mean, yeah, it's somewhat relevant. So I'll overrule the objection. I'm not saying that the board's decision will look what weight, if any, we would give that, but it is relevant. So I'll overrule the objection. Go ahead, Matt.
Thank you. And in addition to that monthly rent, does District Cure have any other fixed monthly expenses?
Yes.
And generally, what do those expenses total on a monthly basis?
Probably $6,000 to $7,000.
Thank you. And if the board revokes District Cure's license, will District Cure also be responsible for continuing to pay those monthly expenses?
Yes.
Mr. Gebre, on average, what would you say that District Cure's gross monthly sales are?
Probably $35,000 to $40,000.
Thank you. And is owning and operating District Cure your only job?
Yes.
And Mr. Gebre, do you have children?
Yes, I have 2 kids.
If the board adopts the OAG's position, the government's position, and orders District Cure's license to be revoked, how will that affect your ability to support your children and earn a living?
It's gonna be hard for me to living a life and supporting my kids.
And if the board were to take the option of a lesser punishment and suspend your license for 30 consecutive days, how would that affect your ability to support your children and earn a living?
It will be hard to survive and continue my business because it's like we paying day to day. We have a lot of expense to take care and survive the business.
And Mr. Gebre, do you understand why the board, or why District Cure was cited for the violations that occurred in January of 2026?
Say that again. I don't understand the question.
Well, I guess let me rephrase. Do you take responsibility? Do you take accountability?
Yes.
For those violations that occurred, and that former employee committed as the owner? Do you take
As a
responsibility?
manager or owner, I will take responsibility.
Thank you. And lastly, Mr. Gebre, is there anything else that you would like to add or that you would like the board to know either about you or about District Cure?
I'm 100% committed to make sure that does not happen again.
Thank you, Mr. Gebre. I have nothing further for Mr. Gebre.
Mr. Southcott.
Thank you. Mr. Gebre, so you supervise the store?
Yes.
How often do you supervise the store?
Every day.
And how long have you been supervising for every day?
Since I opened.
So then you were supervising on January 5th, 2026, correct?
Yes.
I believe these have already been asked and answered.
Ma'am, I'm going to overrule the objection. I don't know where he's going, so.
Okay.
And you were also supervising then on January 8th, 2026, correct?
Yes.
Who are the employees that were working on those days?
The employer name was Mahalit Tasfamariam.
Can you spell that for the record, please?
I can't explain it. Mahalit, MAHELAT space TSFAMRIAL. License ID number 13.
No, you don't need to do that. I just want we have a court reporter, so I just want to make sure that they capture the name correctly. Go ahead.
So was that the Ms. Salamara? Is that right?
Mahalit.
Mahalit. All right. Was Mahalit the only employee that was working on January 5th, 2026?
I was there too.
So you were president at the establishment?
Yeah, but I have a lot of things to do. I don't know exactly. I was not seeing what happened. I mean, me and her, we was working together. I might be in the front or she might be in the back. So we worked at different places. So I don't know exactly that. When the incident happened, I don't know where I was exactly that time.
Okay, so what is involved in your supervision?
What is involved in supervision?
Of the store. What do you do to supervise?
I mean, everything as much as I can. All my part, I'm doing all my part.
So you testified that you became aware that Mahalit was selling cannabis to individuals who did not have a medical ID card when you received the notice from ABCA about this investigation, correct?
Yes.
Okay. And after that occurred, Did you conduct any internal investigation into Metric to ensure that all information was entered accurately by Mahalit?
No.
Okay. Have you ever conducted an internal investigation into Metric to ensure all information entered by your employees is accurate, including patient information?
I mean, I did my best.
Okay. How long had Mahalit been working at District Cure?
Probably like 6 weeks.
6 weeks. And when did they stop working at District Cure?
As soon as I received the ABCA showcase, I start asking her a question. She got nothing to answer me, and as soon as she left the workplace, she don't answer my phone. She never came back.
Okay. Is it standard procedure for customers to pay for cannabis products by sending Cash App payments to employees?
Objection, Your Honor. Excuse me, Chairman. This is outside the scope of the direct.
But
This is
it's part of the stipulation. I mean, the party so. I mean, it's part of the stipulation that it's in the record.
Thank you.
All right, go ahead.
So again, Mr. Gebri, my question was, is it standard procedure for customers to pay for cannabis products by sending Cash App payments to employees?
No, totally wrong.
And can the establishment track sales that have been made to their employees via Cash App?
I don't understand that question.
Could you see if somebody was making a sale to one of your employees on Cash App? Would you have access to that employee's Cash App?
No.
Okay. Who is Iris Dagany? I apologize if I'm butchering the name, but Eyerusdagne.
I never heard that name.
You've never heard of the name Eyerusdagne?
Iris, no.
I'd like to introduce Government's Exhibit 5. If I can...
Mr. Oren, allow Mr. Southcott to share his screen, please.
Or rather, this is not Government's Exhibit 5. This is Respondent's Exhibit 5.
I don't know what it is. Hold on. I don't know what it is. I'm just having him. I'll ask Mr. Oriana to allow you to share your screen so you can identify what the document is. Miss Skinner, do you have an objection?
Yes, I mean these are the respondent's exhibits.
Yes, and
well,
they've been entered into evidence.
They're not in evidence. They are part of the disclosure that both parties disclosed, and then someone has to move them in evidence at some point. But because they're there, I mean,
Mr. Chair,
what you're doing.
I would object to the government moving respondents' exhibits into
He is not asked to move you, and he can't move your document evidence. All he's doing is asking your client to identify.
So, Mr. Chair, I'll note that in the stipulations, the parties stipulated to the admission of defendants' exhibits 1 through 5, which includes this exhibit.
I don't have the stipulations in front of me, but Ms. Skinner, is that correct?
Yes, that is correct.
All right, go ahead, Mr. Southcott. Well, we still haven't gotten there as yet.
Can folks see my screen?
Yes, sir. Where we are right now is just someone asking to identify document. No document has been moved in evidence, so there are no documents in evidence currently. Go along. Go ahead, sir.
Mr. Gebri, do you see this document?
What, this document right here?
Yes.
Says this is to certificate that Abel Gabriel have successfully completed DC new business matrix training. Yes.
And is this you are Abel Gebri, correct?
Yeah. Yes.
So this is certifying that you've completed the DC new business metric training?
Yes.
And what is the date on this document? you see in the bottom left-hand corner.
Let me see. Yeah. 03/31/2026.
Okay, so that's March 31st of this year, correct?
Yes.
Okay. I'm going to move on to the second page of this document. What is this page?
Tedros McConnell.
And who is and
Can we
who is that
can we
individual?
spell hold on, can we spell the name for the record, please? So the court reporter can capture the name.
Yeah, Tedros McConnell.
And
Can
can
you
you
spell
spell
the
that for the
name?
court reporter?
TEWODROSEKONNEN.
All right, hold on a minute then. What is your objection, Ms. Skinner?
I would just like to renew my previous objection. I mean, this isn't refreshing recollection. This is having him just recite things that aren't.
I don't know what he's doing. I think he's just asking a witness. So I don't know what he's doing. So if you're objecting, it's premature because I don't know where we're going there. So Mr. Southcott, what's going on?
So this page is not relevant, but the third page is. So, who is the individual that is listed on this document?
This is Yerus Danya.
Yerus
Can you
Danya?
spell the name?
Yeah.
Can you spell the name for the record, please?
Can you spell the name for the record, please?
Sure. EYERUSDAGNE.
And is Yerus Danye an employee of yours?
Yes.
Are they a current employee of yours?
Yes.
Did you have any conversation with Yerus Danye about them receiving payment on Cash App for sale of cannabis products?
No.
I have no further question for this witness.
Any questions? Hold on, Ms. Skinner. Any questions by any board members? All right, Ms. Skinner, I need to redirect.
Yes. Is it correct? I think we've discussed this when I was asking you questions, Mr. Gebre. Is it correct that in the course of your management of the day-to-day operations that you are the person responsible for ensuring that metric transactions are entered in to the system?
Yes.
And you are personally overseeing those transactions to ensure, or the entry of those transactions to ensure that they are entered in correctly with all the appropriate patient information.
Yes.
And you are also personally ensuring that only individuals that are registered patients that District Cure dispenses medical cannabis to individuals that are registered patients. Is
Yes.
that right?
Yeah.
And that's actually all the questions I have.
All right, thank you. Mr. Gabriel, thank you for your testimony.
You're welcome.
Do you have any other, all right, any other witnesses, ma'am?
No, I do not.
All right, the government Mr. Southcott, prior to arresting, are there any documents you wish to move into evidence?
Just noting that the government's case report and attendant exhibits are already in evidence as per 23 DCMR section 171310. But nothing beyond that.
The case report is in evidence. So they know that. All right. Okay, fine. So the case report is, and Ms. Kenner.
To the extent, sorry, apologies, Chair.
No, I was just asking you, ma'am. You did have the witness testify to 2 documents. They have not been moved in evidence. So I'm just saying, do you want them?
Yes,
Are you there,
yes,
ma'am?
we would like to move exhibits 3 and 4, apologies, into evidence. Thank you, Chair.
Mr. Southcott, do you have any objection?
No objection. I'll just reiterate that I believe defendants exhibits 1 through 5 should be entered into evidence. The district has no objection. to the admission of those documents based on the stipulations that the parties agreed to and sent to the board earlier this week.
No, but I don't know what exhibit 1, 2, and 5 are. No, we've had no testimony on any. I'm sorry, I don't know because I don't even know what exhibit that. Oh, all right. The parties might have agreement, but I don't know what the documents are. I don't know what these documents are that you're asking us to move in evidence. The only document
they were previously submitted by the parties in advance of the hearing.
But okay, we do, but in order for documents to move in evidence, we need to have someone to introduce them for the record. And that's why I was asking. And so therefore we had testimony in exhibit 3 and exhibit 4, and I've moved exhibit 3 and exhibit 4 in evidence, but I don't know what these other documents are. There have been no testimony, so they were never introduced.
But we did hear testimony about exhibit 5.
And okay, so that was right. So, and you want to move exhibit, so I can move exhibit 5 in evidence based on the stipulation. So I can move
Yes.
exhibit 5 in evidence, but I'm not going to move any other document in evidence because I don't know what they are outside of the case report. They have not been identified.
Then exhibit 5 and exhibits 1 and 2 can, because they weren't testified to, we can leave those out of the record.
All right, that's fine. So we'll move exhibit 5, and of course you're correct. The case report is in evidence. Okay. All right, thanks. All right. Do you wish to, as part of your closing, I would like you to answer this question, sir. I know you're asking for revocation, but are there any other penalties available under Title 168? So as part of your closing, maybe you could respond to that for the board. Okay. So if you need to reserve a couple of minutes to look at that.
Yes, I would like to reserve 3 minutes for rebuttal.
Okay, that's fine. Go ahead, sir.
Mr. Chairman and members of the board, told you up front that this case was about trust and whether you could trust an establishment to ensure that the district's laws with respect to the cannabis regulations are being complied with. I believe that the evidence shows that this establishment does not deserve this board's trust and as a result should have its license revoked. In the alternative, the district believes that if the board is not going to revoke its license, then it should impose a 30-day suspension of its license the way that it did in the Doobie District matter, where analyzing similar facts in Order 2026-211, the board imposed a 30-day suspension on a licensee who sold cannabis to unregistered patients. So what this case involves is 4 violations, which have all been stipulated to. In the stipulations, you see that the establishment admits that they violated DC Code 7-1671.05 and 22C-DC Mart 5709.5 on January 5th and January 8th, 2026, when the licensee dispensed medical marijuana to someone other than a qualifying patient or caregiver. And this is about a charge that relates to who the individual is. If they are a qualifying patient or caregiver, then you can't charge them under the circumstance. But because the UC was not a qualifying patient or caregiver, the establishment admits that it has violated those code provisions. The second charge relates to whether the licensee dispensed medical marijuana to someone who failed to produce a valid medical cannabis patient card. And so this is less about who the patient is and more about what the establishment does with respect to checking to ensure that it is only selling to people who have valid medical cannabis patient cards. And in this instance, on January 5th, 2026, the record demonstrates that this employee specifically asked the UC if they had a medical card, got the answer no, and still chose to sell to them. Now, this is notable because Mr. Gebre testified that he was present, that he was there at the establishment, and he was supervising, supposedly, on both this date, January 5th, 2026, and January 8th, 2026, when the second UC buy occurred. And so similarly on charge 3, that charge has been substantiated based on the stipulations because the licensee failed to take steps reasonably necessary to ascertain whether a person is a qualifying patient or caregiver in violation of 22C DCMR section 5612.2 when it dispensed medical marijuana to the second UC without asking for their ID or medical cannabis patient card. Again, Mr. Gebre was present and supposedly supervising these. The only other employee in the small retail shop when this occurred. Finally, on the last charge, on both January 5th and January 8th, 2026, the licensee failed to enter true and complete information into the metric real-time electronic record system in violation of 22-C DCMR section 5615.3 when it entered incorrect patient information into the system following those sales to UC1 and UC2. Now, Mr. Gebre testified that he is now the person who is supervising and entering in the information into metric, but he also testified that he never conducted any investigations into whether his employees were entering in incorrect patient information.
Objection. I think that's a mischaracterization of Mr. Gebre's testimony.
All right, let's not object during closing, but you can, in your closing, ma'am, why don't you just bring that to the attention of the board? Okay.
Thank you.
Mr. Gebre indicated that he had never conducted an investigation into metric about incorrect patient information. He indicated that he had never conducted an investigation into metric about whether the employee who was working on those days had, in other circumstances, entered in incorrect patient information. So we do not know that this is the only 2 instances that this conduct occurred. There could be many others. Mr. Gebre testified that the employee had been working for 6 weeks prior to this incident. But also noteworthy in this is that during both of the sales, the stipulations indicate that the money was sent for the transaction to Ieros Danye's Cash App account. Now, Mr. Gebre testified that Cash App is not an acceptable way for the establishment to be conducting its cannabis sales. But he also testified that Ieros Danye is a current employee of the establishment. And so when this board is considering whether this establishment is trustworthy enough to be continued to allowed to have a license based on Mr. Gebre's supervision, it needs to look at the record, which establishes that there has been a history of selling to unlicensed, or rather unregistered patients, that there has been a history of employees supposedly operating under his supervision who have sold cannabis products, either legal cannabis products or illegal cannabis products.
Objection.
To individuals.
Mr. Selpa is trying to backdoor facts that are not in evidence.
Ms. Skinner, let's not. I'm not going to have you objecting to during closing, ma'am. If you need to correct the record during your closing, you can do that. But we're not going to have any more objection during closing. Okay. All right.
To the extent that the board, I will ask the board to take notice of order number 2025-085, which deals with this establishment, which deals with testimony from this owner, and which deals with the findings of fact and conclusions of law made at that, where the board found that the male employee working at the licensed establishment took the UC upstairs to the second floor, and that the undercover agent was able to purchase cannabis, which were later tested positive for THC. And there was no evidence that the bag contained any labeling identifying the source of the product or the THC contents of the cannabis inside the bag. It is quoting directly from the findings of fact and conclusions of law in that case. There is a history here then of Mr. Gebre saying that he is properly supervising, and then there is evidence in the record suggesting that that supervision is insufficient. If he was present on January 5th and January 8th, 2026, as he testified that he was when these transactions occurred and was supervising, then that supervision was insufficient. If he was present, he is aware that based on the case report, which is how he became aware of the violations that occurred on those dates, that case report indicated of Iris Danye, who is the individual on the Cash App who received money through those transactions. And yet Iris Danye remains an employee of Mr. Gebre. As a result, the district believes that this is not an establishment that can be trusted to continue to operate in a licensed fashion. Now, earlier in opening, opposing counsel noted that revocation would only be appropriate where the government can show that the licensee's conduct is so egregious as to show an imminent harm. This is simply not an accurate statement of the law. DC Code section 7-1671.06b1 states the ABC board may fine, suspend, or revoke the license or regulation of a person or business found to have violated any provision of this chapter or rules included under this chapter. And that includes all 4 of the violations at issue in this hearing. It is absolutely within this board's authority to revoke their license based on the present, and the district does not need to demonstrate that there is any degree of imminent harm for them to take action to revoke their license. However, the board does not want to pursue revocation, then the district believes a 30 consecutive day suspension of the license would be appropriate under the board's prior decision in order number 2026-211, which dealt with Doobie District, where similarly there were 2 charges there. The first for dispensing medical marijuana to someone other than a qualifying patient or caregiver, and entering false information into metric in violation of 22 CDC MAR 5613.3. Both of those charges are present in this case, as well as additional charges in this case. Those charges are appropriate, and the mitigating circumstances that opposing counsel referred to are not mitigating circumstances that warrant against revocation. Revocation may be punitive, but that is the result of the establishment's conduct, and whether the establishment has a lease that is ongoing, whether the establishment is a small business, whether the owner's only course of employment may be through that business and the consequences on their family have no bearing and no relevance with this board on what the appropriate penalty is. To do so otherwise would be to ignore that the penalty schedule is set up as a result of determining what is appropriate based on the conduct of the establishment and not the circumstances of the establishment with respect to their financials. As a result, the district believes that revocation in this circumstance is appropriate in light of this establishment prior history and the conduct at issue in this particular instance. Thank you.
Thank you. All right, Ms. Kinner. I can't hear you, ma'am. You're on mute.
I would like to renew my objection regarding the government's insistence on introducing facts that are not explicitly part of the board's of the facts that respondent has stipulated to. I was not a party. I was not the attorney on whatever previous instance may have occurred that may have come before this board, and it is inappropriate to raise matters that the board has already adjudicated here. The board can, of course, take that into account as it is part of the greater record, but to specifically recite facts that we have not stipulated to, we believe is inappropriate, and that is why we're renewing the objection with respect to any specific factual references to the other board order or to anything that occurred previous to January 5th, 2026. I would also like to correct a few things that Mr. Southcott mentioned before I kind of get to the meat of my closing. There is nothing illegal about an employee accepting payment. That is an issue that Mr. Gebre, it is his job to deal with that on his own. That is not under the purview of ABCA. ABCA cannot dictate how a licensee accepts payment if ultimately that transaction was entered into metric, which there's no dispute that it was entered into metric here. It's just that an unassigned patient number was also entered in. So I would also object to any implication that somehow Iris Degne accepting money via Cash App is a violation in and of itself. That is not correct. I would also like to, correct Mr. Southcott's allegation that Mr. Gebre never conducted any follow-up investigation. He said Mr. Gebre testified that he confronted, the employee whose name begins with an M that I can't begin to pronounce, and forgive me for that. But that is not, that was an investigation. He also testified that since then, he has been the party who has been responsible for ensuring that daily closing procedures include verifying every transaction that's been entered into metric, right? He took those steps after this happened. Mr. Gebre also testified that he retrained his staff and he retrained himself. So any implication that because his certificates were marked in March, that he didn't initially take that training is false. And there's no evidence to that effect. Mr. Gebre testified he retrained and he recertified. Okay. So those are the Mr. Southcott's most that's what I'd like to correct just for the record there. And Mr. Southcott is correct. The board has the discretion to revoke a licensee's license on the basis of any violation in the chapter. But not all violations are the same. Mr. Gebre did not sell unlicensed product. District Cure and Mr. Gebre did not oversell patient accounts by 39 grams, which Mr. Southcott did bring up Doobie District, and failed to mention that one of the issues there was that they oversold multiple patient accounts. Employees of Doobie District oversold multiple patient accounts to the tune of over 36 grams. That is not the case here. Okay. The case is an employee who, if anybody here has ever been a small business owner, you know that the owner cannot be in every place at once. An employee who may not have been, admittedly, been trained or had the appropriate level of supervision at that time, made a mistake, and she's no longer an employee there. Okay, Mr. Gebre is, and you heard him say that he is committed to ensuring that the business that allows him to support his family is compliant with ABCA's rules and regulations. Talking about community trust, I don't, that isn't the standard, right? Certainly community trust is not the standard. And the closer standard would be imminent danger, right? Because DC Code 71671.08 does have that imminent danger standard. So trust is certainly not the standard. It is important for the community to have trust in the licensee, but I don't see how that was eroded here. And of course, the board should also have trust in the licensee. And I think we've made it clear why the board should trust Mr. Gebre to continue, which he has been since January 8th, 2026, operating District Cure in a compliant manner. So the government here is recommending revocation, which, as I mentioned earlier, is essentially a death penalty for a licensee. It is extremely relevant, the sort of financial penalty that will that Mr. Gebre will face if District Cure's license is revoked. I mean, that is a real consideration. We are not, I don't believe the board is in the business of just applying a one-size-fits-all approach to facts and to licensee circumstances. And I don't believe they're in the business of forcing businesses that have made a mistake to shut down. It is unduly punitive and disproportionate to revoke District Cure's license, disproportionate to the violations at issue here that we have stipulated to. The government has not demonstrated how their continued operation presents any sort of imminent danger or even erodes the community trust. And of course, I'm not suggesting that district cure shouldn't face some sort of consequence. Mr. Gebre took responsibility for the violations. And we just don't agree with the penalty that the government is requesting here. District Cure has been open and operational since the January 8th violation. And over those more than 7 months, District Cure has not been cited by ABCA for any subsequent violations. I think that in and of itself is a testament to Mr. Gebre's ability to safely manage District Cure and to be appropriate person to have that community trust. Mr. Gebre has implemented measures to ensure that District Cure's operations remain compliant. He personally oversees day-to-day operations, and he will continue to do so to prevent future violations. As Mr. Gebre explained, District Cure is his livelihood. It is how he supports his family, and he certainly doesn't want to jeopardize that. So I would ask you to trust him here, that he will not do something to jeopardize that, and he will ensure that none of his employees do either. Revocation is completely unwarranted in this instance. But so is a 30-day suspension, particularly if that 30-day suspension is imposed consecutively. You heard Mr. Gebre testify that if he has to close District Cure for 30 days, he couldn't reopen. Based on District Cure's current monthly sales, average monthly sales, a 30-day suspension is tantamount to constructive revocation. And on top of that, the lost sales that equate to $35,000 to $40,000 each month. That is almost impossible for a business to come back from, losing that kind of revenue. And so I think it's important for the board, when it's considering the appropriate penalty, to understand the practical and real effects of that penalty. And we would suggest that a penalty, that a remediation plan and a small fine would be more appropriate in this instance, as opposed to revocation or a 30-day suspension, which we believe serves no other purpose than to punish Mr. Gebre and District Cure, as opposed to actually ensure that this never happens, that there are no further violations. Thank you. That's all I have.
Very briefly, Mr. Chair. There's 2 points that I'd like to address. The first is Ms. Kinner's statement that there's nothing illegal about an employee accepting payment via Cash App. This is true in the sense that the district isn't bringing any charges related to the fact that the money was communicated on Cash App. And so the concern isn't that there was a violation, but rather that when Iris Danier accepted a Cash App payment. But the concern is that Mr. Gay said that his employees should not be accepting payment via Cash App, yet he is currently employing an individual who did receive several Cash App payments for transactions which involved individuals who did not have ID cards. The second point is that brought up over Doobie District and in attempt to distinguish district pointed out that there was an overselling issue in that case, and said that that's not instance here. And the fact of the matter is, you don't necessarily know that's the case. When you have an individual who is assigning transactions to incorrect patient accounts, there is no way to track whether an individual has been oversold. And this is one of the many health and safety concerns that exist about why the metric information has to be accurate as to patients, is that if you are unassigning or applying a sale to an unassigned account, then there is no way to determine whether that sale should in fact be going to an assigned account and whether that individual is then potentially being oversold. It's why the information has to be accurate. Now, towards the end of her close, Ms. Kinner said, "I will ask you to trust him here," referring to Mr. Gebre. And I think that's what this case boils down to, is whether this board can trust Mr. Gebre to be an owner who is capable of supervising his employees and his establishment in determining that they are complying with the laws of the district and the cannabis regulations. And I submit that the record demonstrates that he is not. if he was present on the days where these two sales occurred to an individual who did not have an ID card, then that is not adequate supervision. If he is employing individuals repeatedly who are engaged in this practice where they're selling marijuana to individuals who do not have medical ID cards, that is not adequate supervision. And for this reason, the district believes that revocation is the appropriate penalty in this circumstance. Thank you.
All right, thank you. The record is now closed. Do the parties wish to do propose finding of fact and conclusion of law, or waive the
Nothing
right
from
to
the
do so? I'm sorry, you
No.
said what, Mr.? I didn't hear what you said, sir. Mr. Southcott, I didn't hear what you said. I didn't.
Sorry, nothing from the district.
Okay.
Would the board allow me a moment to confer?
Sure.
Please, thank you so much. Yes, thank you, Chair. We would like to submit proposed findings of fact.
We're fine. I think it's relevant, since you're doing that, maybe you can address that issue regarding charge one.
Thank you.
Yeah.
Thank you, Chair.
All right, so the transcript for this case will be available in approximately 3 weeks, and 30 days from the receipt of the transcript, the proposed finding of fact and conclusion of law are due. All right, so let me close this case then for, all right, so as chairperson of the Alcoholic Beverage and Cannabis Board, and in accordance with DC Official Code Section 2-575 of the Open Meetings Act, I move that the board hold a closed meeting for the purpose of seeking legal advice from our counsel on case number 26CC00001, District Cure Dispensary, pursuant to DC Official Code Section 2-575B4A of the Open Meetings Act, and deliberating upon case number 26CC00001, District Cure Dispensary, for the reasons cited in DC Official Code Section 2-575B13. Is there a second?
Mr. Grant, I second the motion.
Mr. Grant has seconded the motion. I will now take a roll call vote on the motion before us now that it's been seconded. Mr. Grant.
Mr. Grant, I agree.
Ms. Quinn.
Ms. Quinn, I agree.
Mr. Meadows.
Mr. Meadows, I agree.
Mr. Jones.
Mr. Jones, I agree.
Mr. Turner.
Mr. Turner, I agree.
Mr. Anderson, I agree. As the motion has passed 6-0, I give notice that the board will recess to hold a closed meeting pursuant to Section 2-575 of the Open Meetings Act. Thank you very much for your presentation today. Again, the proposed finding of fact and conclusion of law, they're due to the board 30 days after the receipt of the transcript, and stated the transcripts will be, you should receive the transcript in approximately 3 weeks, and approximately 90 days after that's submitted, we will issue a decision. Thank you. Have a great day.
Thank you so much. Have a wonderful day.
All right, fine. Prior to closing the record, I'm going to ask the board to return to executive session. We have two additional agenda items. So I'm not going to close the record. The board will move. All right. Let me before and let me figure out how to do this. The board is going to go into executive session. Hold on. I do not want to run afoul of the. All right, so. The board will go into executive session to to review an ongoing or planned investigation of alleged criminal or civil misconduct or violations and obtain legal advice from a legal counsel on the matters appearing before the board's licensing agenda. And that's the purpose of the board going in an executive session. Okay, so we'll go in executive session, and so we'll be back shortly. Thank you.
Chairman, you're on mute.
Let's start at the beginning. That's one of the reasons why I'm trying to read from the computer screen. Didn't realize that. Hold on. I apologize. I was reading from the computer screen. Didn't realize that I was on. So let me start at the beginning. Let me go back. All right. Okay. All right. I thought I put myself back on mute again. Hold on. All right, so this is the medical cannabis licensing supplemental agenda. On the medical licensing supplemental agenda, there are three licenses. And so I would review all three in the record. Then I will also review the recommendations, and I'll make a motion for the board to approve the recommendations put forth by the chair. Number one, review of reinstatement request, Smoke and Tings, license number 127560. The recommendation is approval. Number two, review of safekeeping request. This is for Smoke and Tings, license number 127560. Recommendation approval through March 31st, 2027. And number three, review of request to convert standard manufacturer type 1 license to conditional manufacturer license. This is for Fire Tune, license number 125461, recommendation approval. I therefore make a motion that ABC board members vote to approve the recommendations put forth by the chair for the medical cannabis supplemental agenda. Is there a second?
Ms. Quinn, I second.
Ms. Quinn, I second the motion. We'll have a roll call vote. Mr. Grant?
Mr. Grant, I agree.
Ms. Quinn?
Ms. Quinn, I agree.
Mr. Meadows?
Mr. Meadows, I agree.
Mr. Jones?
Mr. Jones, I agree.
Mr. Turner?
Turner, I agree.
And Mr. Anderson, I agree. And Mr. Anderson, I approve. The matter passes 6-0. All right, let me find the other agenda. The second agenda, it's the medical cannabis license administrative docket. And on that docket, there is one applicant, and it's the trade name is the Dispensary Medical Cannabis Retailer with Delivery Endorsement, Transfer of Ownership, Social Equity applicant, formerly Smoke and Tings, license number 127560. I make a motion that we approve this agenda item. Is there a second?
Mr. Meadows, I second.
Mr. Meadows, I second the motion. We'll have a roll call vote. Mr. Grant?
Mr. Grant, I agree.
Ms. Quinn?
Ms. Quinn, I agree.
Mr. Meadows?
Mr. Meadows, I agree.
Mr. Jones?
Mr. Jones, I agree.
Mr. Turner?
Turner, agree.
Mr. Anderson, I agree. The matter passes 6-0. We're now at the end of our calendar and agenda items for the day. And so now let me close the record. As chairperson of the Alcoholic Beverage and Cannabis Board for the District of Columbia, in accordance with the Open Meetings Act, DC Official Code Section 2-571 et seq., I move that the ABC Board hold a closed meeting on September 2nd, 2026, for the purpose of discussing A, reviewing ongoing or planned investigations of alleged criminal or civil misconduct or violations and obtaining legal advice from legal counsel on the matters appearing on the board's investigative agenda. B, obtaining legal advice and counsel and to review trade secrets, commercial and financial information related to matters appearing on the board's licensing agendas. C, obtaining legal advice and counsel and to deliberate on administrative judicial matters appearing on the board's legal agendas. D, discussing the logistics, regulation, and schedule of the day's meetings. And E, reviewing personal matters and the administration of the district's alcohol and medical cannabis laws and regulations in accordance with DC Official Code Section 2-575B be 4, 11, 13, 14, and 25-204.01B and C for September 2nd, 2026, as published in the DC Register on August 28th, 2026. Is there a second?
Mr. Jones, I second the motion.
Mr. Jones, to second the motion. I'll now have a roll call vote. Mr. Grant.
Mr. Grant, I agree.
Ms. Quinn.
Ms. Quinn, I agree.
Mr. Meadows.
Mr. Meadows, I agree.
Mr. Jones.
Mr. Jones, I agree.
Mr. Turner.
Mr. Turner, I agree.
Mr. Anderson, I agree. As the motion has passed, I give notice that ABC Board will hold this aforementioned closed meeting. Notice will also be posted outside ABCA's offices and the calendar on ABCA's website and published in the DC Register as soon as practical. Today is our last meeting until September. I would like to thank all members of the public who participated in our hearings today and all members of the ABC Board who give their time and talent to ensure that this board succeed in its mandate. Thank you very much for your attention and your time, and have a wonderful summer. I will see you on September 2nd. We're now adjourned for the day. I ask all board members now to return to executive session for some closing matters. Thank you.